Yes,
My lord, I'd like to mention one listing of a motion, my lord, is
yes,
on 19th.
yes. What is the matter
My lord, regarding the settlement of ferry service, my lord, this is
regarding?
settlement of ferry service. Ferry service, my lord.
Yes.
So against the single judge order that was earlier listed before lordship, there is a hurdle of my lord limitation that has been over. So I might pay it to be listed on 19.
19.
Friday, my lord.
Admission anytime.
Friday, 19.
Must suppose.
Adjournment request, if any, from item number 1 to 4. From item number 5 to 11, adjournment request. From item number 12 to 25.
Maybe your lordship, I apologize for mentioning this matter without any prior intimation. Lordship, item number 21, lordship, I am appealing for the respondent, lordship. I need some an accommodation for today, your lordship.
You're appearing for respondent.
Yes, sir.
Have you?
I'm appearing for the petitioner.
When you want?
After vacation.
Any
your
date,
lordship.
date may be fixed.
A prayer for adjournment has been made on behalf of the respondent. The land council appearing for the petitioner does not have serious objection to the adjournment. Let this matter come up consideration on after the holidays, anytime, fix a date.
2017.
I'm deeply obliged, madam.
Much obliged, lordship.
From item number 26 to 31, adjournment request. Any other request?
May I please, Lordship?
Yes.
Lordship, I have filed an interlocutory application, my lord, on 10th of September, my
For
lord.
what?
My lord, since the matter is pending, Hindi teacher selection and appointment, my lord. And my lord,
You asked for early posting of the matter.
no, my lord, I do not know, my lord, since only this in the returnable date was 4 weeks. So, my lord, in the meantime, my lord, the post will be filled up. And once the posts are filled up, nothing will remain in the repetition, my lord. So,
So it is, the matter is slated to be listed when?
my lord,
Ordinarily, without your mentioning,
yes.
when would it have been listed?
No, that in my case, my lord, it was after 4 weeks.
4 weeks, we always give a date.
This way. From this way.
Okay. So let's see if the date has been fixed, then perhaps we'll hear it on that date,
Check.
or you make a mention, you file an IA. For
Yes,
a
already I have
pre-hearing.
filed the,
All right.
can you, no,
We'll have it.
lords.
May I plead
Give a
your
date.
lordship?
IA को ले लो.
May I plead your lordship?
On 19th.
19.
On 19th. This week.
You cannot have choice like this. Or, yes,
Lordship, in item number 23, your lordship,
yes.
the executive engineer has filed affidavit on 10th of September, your lordship, as per lordship direction. That is not on record, your lordship. May I permitted to call it on record, your lordship?
So you have filed it, no?
Yes, yes.
Now, once you have filed it, it's our business to have it on
Yeah.
record. Let it be posted. We'll adjourn it for a week or so. You be here.
Obliged, your
All.
May I please, Lord? I'm praying for listing, my lord. I have filed a contempt petition on 10th September. So kindly,
After all.
After holidays.
my lord, before holiday, kindly.
We don't.
Obliged, man.
15th October. 15th October. Daily list for order, item 1.
May I please, Lord? My lord, here, my lord, the service upon the respondent 4 and 7, my lord, that is complete, my lord. And their names are also reflected. So in that case, your lordship may post this matter for admission after vacation. my lord.
It appears that all the respondents have been served and are represented also by their respective councils. Don't write S, huh? Respective council. Let this matter come up for consideration under the appropriate heading on give a date.
24/10.
Obliged.
Item number 2.
May I please your lordship? My lord, we have entered appearance for respondent number 4 to 8.
Right?
My lord, 2 weeks time may be granted for filing our objection.
My lord, may I please your lordship? My lord, this matter may not likely be taken up by this bench.
Will not. Item 2.
Yes, your lordship.
This is item 2.
My lord, item 2.
What is the problem?
I don't know.
My lord, the judgment challenge in this, my lord, read appeal
My lord, earlier appeared in this case, my lord.
Let this case go out of our list and be
Well-
placed before an appropriate bench,
Well-
which one of us, bracket Justice Arun Dev Chaudhary, is not a part. List this matter before it, or it goes directly to the registry committee. Don't need
My lord,
to-
maybe taken up next available competent bench, my lord.
Let it be, let the case be listed before the Chief Justice in the administrative side for allocating a bench.
Highly obliged, your lordship.
Item number 3. Please say.
Same order in item number 3. All right.
Item 4.
Delay of how many days?
My lord, delay of condemnation, my lord, 4507 days, my lord. Reason is, my lord,
And
that
what is the explanation? The other side has appeared, no? You have appeared?
yes, your lordship.
Yes, what is the explanation?
My lord, explanation is that, my lord, petitioner, the applicant was not a party before the single bench of this court, my lord, WPC number 256/2013, para 4, my lord.
You
My
have
lord,
not made
that
out a
notice
case.
may be issued
Oh,
at this-
you had argued on the last occasion, no? We had given you some time.
That, my lord, another case, my lord. My lord, only a notice may be issued. my lord,
No,
this is
notice is not necessary, she is here. We are not condoning the delay, dismissed.
Much obliged.
Item number 5.
Coming for the first time,
Lordship.
notice.
Lordship, other side is appeared by through
Yes.
caveat.
You have any objection if the delay is condoned? 168 days.
168 days.
We start probing for the grounds only when the delay is more than 300 days. That's an artificial outer limit that we have fixed for this court.
Yes.
Allowed. Delay condoned for detail either na. हमें क्या format में होता है. Okay, here's format. All right.
Next date.
Date to be, no, give a date. Is this for admission on so and so date? October. After summer, after puja holiday.
17th October. Item 6.
Notice has to go.
Yes, ma'am.
It's number 1 to 14.
Yes, madam.
Normally, if somebody would have appeared, we would have condoned the delay.
Yes, ma'am.
Notice,
Obliged, Lordship.
both modes returnable on give a date.
2710. Item 7.
May it please your lordship.
Coming for the first time?
Yes,
Or
ma'am.
she is here? You want to contest?
Lordship.
How many days delay? 455.
Years. Full file, objection.
This is an application seeking condonation of delay of so many days in preparing this appeal. The land counsel for the respondent has appeared and submits the necessary affidavit on behalf of the respondents, challenging the prayer, opposing the prayer made in the application shall be filed, is required to be filed. Let such an affidavit be filed by the next date to notify friends for day.
Much obliged, lordship.
2810. Item number 8.
May it please your Lordship.
13 days only
17
then
days might.
after respondent is here.
Yes.
We cut
I have
the delay.
to-
Allowed. To be fixed for admission on so and so day.
3110.
Obliged.
Item number 9.
Yes,
Your Lordship, this order has been passed in similar matters. This matter may also come up along with the other similar matters. It is fixed on 22nd October.
all right. In terms of the same order and list this along with writ appeal number so and so, on so and so date.
Much obliged.
For admission, item 10.
Yes,
No, I appear for the respondent recognition on that.
who appears for FCI? Nobody appears on behalf of the FCI slash appellant. The counsel for the respondent is present. Re-notify so and so date after some, after. all information.
1610. Item 11.
Yes,
My lord, I'm praying, my lord, let this matter be passed over for the time being, my lord. I'm led by my lord, senior counsel, he's on way, my lord. Yes, my lord.
all right, so we hear you tomorrow,
Tomorrow,
today, anytime,
today, my lord. After some time, my lord.
after lunch.
I'm so obliged.
This is the fitment table.
Yes, my lord. Fitment table.
Yes.
Item 12.
May I please your lordship, my lord? Lordship, in similar matter, lordship has already passed an order, lordship.
Have we?
Yes.
Let's see.
The honorable single judge has passed the order, lordship, relying upon the judgment, lordship, which has division bench already set aside, lordship.
What about the STLP?
Against this, the Supreme Court has been approached, my lord, and according to Supreme Court,
Supreme Court only issue notice,
take the
lordship.
recovery, my lord.
Only recovery part, lordship. So, madam.
Last annexure is the Supreme Court's order, my lord.
One of the judgment passed by this.
Yes, lordship.
My brother. So let this go out of our list.
My lord, my lord.
Let this case go out of.
My lord, my name may be shown, my lord, for the respondent. My name is not shown, my lord.
Your name shall, let this case, go the same order.
Yes,
Henceforth, the name of the land counsel for the respondent. We proved it in the cause list.
Right.
Deeply obliged.
Item number 13.
Item number 13, lordship, may kindly take up this matter after some time, lordship. This is a high court matter, lordship. Arguing counsel may.
Mr. Das, is there a matter in the supplementary list also related to this?
Yes, my lord,
Uh,
connected matter,
Both of it should be taken up together
my lord. Item 40, my lord.
with the supplementary.
Much obliged.
Item number 14.
May it please your lordship, the present matter has been filed against the common judgment and order of the learned single bench, my lord. And the other matter also has been challenged in the form of an appeal, but that has not been listed today. But this matter, your lordship, pertains to continuation of service of contractual employment of the appellant, my lord, as an assistant professor. So that is the matter, my lord. And in the order of the single bench, the learned single bench in page 267, my lord, has granted the relief that the petitioner may approach the college authorities by submitting an application therein and stating that they are willing to continue in the college as contractual faculty, my
What
lord.
else did you expect?
Lordship, at this stage, Lordship, Lordship, there's a gap in the service because of the termination order, my lord.
Contractual, no? This
But
is also this was beyond the domain. It was only an indulgence given by the land skill judge.
Yes, my lord. But Lordship, in light of the recent judgments in Jaggo and
Jago is absolutely different. Jago, we know.
Lordship, however, but no new contractual employees have also been engaged in the meantime, as per the information we have gathered.
Take it. We have heard so and so. The appellant has challenged the judgment dated 4/8/2025, passed by a learned single judge of this court in WPC number 5617 of 2024, whereby the prayer made on behalf of the appellant has been rejected. The appellant, it appears, was first appointed as a contractual faculty member in the Department of Commerce in Tinsukia Commerce College through an appointment letter dated 10/7/2013 for the session July to December 2013. And subsequently for the session commencing from January 2014 to December 2014. His contractual engagement was extended by another appointment letter dated 10th of January 2014, determining his contract up to 15/12/2014. It appears that even after the expiry of this period, the appellant was verbally directed by the college authorities to continue in service. He accordingly discharged his duties without break or blemish in his performance for several years. His presence as a faculty member in the college helped the institution attain grade A accreditation in the National Institutional Ranking Framework, in the grade A in the National Assessment and Accreditation Council assessment. What have I said? In the NAC, National Assessment and Accreditation Council. His presence in the faculty, along with other contractual staff, was relied upon to maintain the required student-teacher ratio, which was one of the important facets of determination for granting grades under the NAC. However, the appellant grieves that despite this, by office memorandum dated 18/2/2019, the governing body of the college, in its meeting held on 11/9/2023, resolved that all temporary teachers in the stream of commerce would henceforth be engaged only for 89 days due to paucity of funds, and in consonance with the policy decisions. Consequently, the appellant was issued a fresh appointment order dated 29/9/2023, restricting his engagement for a period of 89 days on contractual terms and conditions. Because of this, his salary was also withheld from October 2023 onwards. His representations to the college authorities remained unanswered, and the learned single judge did not revoke the conditional contractual appointment of the appellant. Did not agree to interfere with the decision of appointing the petitioner, appellant, on contract for a limited period of 89 days. However, by the impugned judgment, the learned single judge granted liberty to him and similarly placed teachers to approach the college authorities by submitting applications if they at all wished to continue as contractual faculty, but strictly in terms of the governing body's decision. The appellant has prayed. The appellant has raised objections on the ground that the learned single judge did not at all advert to the legitimate expectation of the appellant for being at least given temporary appointment, for being at least given contractual appointment for whole of the session. Stop. It was a violation of Article 14 in the sense that the appellant was treated as a contractual faculty for only 89 days, despite comparable work and tenure with the regular staff. Stop. This, according to the appellant, is arbitrary and discriminatory. Stop. The appellant has thus prayed that he was entitled for regularization of service in the light of long and uninterrupted performance of regular duties, despite the initial appointment being contractual. The continuation of the appellant in the college as a contractual faculty would definitely not clothe him with a right to claim to have his service regularized against a sanctioned post. It appears from the records that the government of Assam in the higher education department by OM dated 18/2/2019 has barred the provincialized colleges from engaging any person as a teaching/non-teaching staff where no sanctioned post exists for the purpose. The governing body of the college in question, namely Tinsukia Commerce College, is under an obligation to comply with the said directive contained in OM dated 18/2/2019 referred to above. Despite this, and notwithstanding this, the governing body of the college had noticed and realized that the continuance of the services of contractual faculties would be necessary for providing uninterrupted classes to the students. With this background, with this background fact and assessment, the governing body of the college proceeded to resolve the issue by appointing contractual faculty afresh for a period of 89 days in view of the restrictions imposed on the authorities and also for the reason of the financial constraints faced by the college. The contractual engagement of the appellant had ended in the year 2023, which was never extended. The learned single judge, therefore, was absolutely justified in not exercising his judicial discretion in substituting that decision of the authorities of the college. The period of contractual engagement of the appellant could not have been extended beyond 89 days. it was only in this circumstance that that an observation was made by the learned single judge that in case the appellant would require his services to be continued for 89 days in a year, it could approach the college administration. And in that event, the college administration shall look into such request and pass necessary orders accordingly. We do not find any reason to interfere with the judgment impugned. There is no merit in this petition.
Item 15.
May I please, your lordship?
Yes,
This on the last occasion,
13.8.
I received the instruction on the last occasion, my lord, they have submitted a communication. In the second paragraph, they have stated that, my lord, I have not proposed the amount to be paid and the way how to pay,
Justified.
justified.
That is justified.
Yes,
That
now I,
is absolutely justified.
yes, now I have submitted a proposal, my lord, before the, my lord, authority for consideration, my lord.
Total, what is that proposal?
Proposal is, my lord, I am ready to pay 90 lakhs.
No. The entire dues plus cost plus whatever, everything. 13.8 says so. It is only a protective umbrella to the borrowers.
Lordship, lord.
But it can't go, the protection can't go beyond the statute, no. Not that we wanted.
Yes, my lord.
This statute wants it.
From the communication they made, my lord, it appears that, my lord, there is a, my lord, they can consider OTS, my lord, proposal. On that only I am, my lord. If they can, physically, I'll appear before them, my lord. If they negotiate and if they decide anything, my lord, I'll oblige to that, my lord. And I am ready to pay 1/3 of the total amount.
So that is for them to decide. He's shaking his head in the negative.
My lord, I'll physically appear before them, my lord, tomorrow, my lord.
Well, we can give you an adjournment.
Yes, no. I'll,
Next, I don't think any bank authority, any creditor would agree to your proposal, especially in view of the statutory
Yes, my lord.
compulsion on you to make payments of the entire cost, charges, expenses along with the dues.
Yes, my lord. But going through the letter, last communication.
Delay, the difficulty is this: if you delay, they'll issue a sale notice,
Yes, my lord.
and then perhaps this also would not be available to you
Lordship.
under the service.
By this week, my lord, lordship will take care of matter. Day after
You want
tomorrow.
adjournment? We are ready to grant.
Yes,
you an
yes,
adjournment.
yes, my lord.
The problem with us is the value of the property is at the higher side.
That
That is why,
That's right. That's for you to decide. You want your money back. The purpose is to claw back the money from the borrower.
right.
Now, if you can give him some latitude, we are not asking you to do that.
Yes.
That's your choice.
Yes.
But then statutory bar, all right, statutory protection, all right, but you can always decide that's your business dealing. So we are only granting him time.
Yes, ma'am.
And in the meantime, if you come up with a sale notice, this becomes infractuous. And we are also not asking you to withhold that. Right? As prayed for on behalf of the petitioner, the petitioner, re-notify next week.
My lord, and in the meantime, that may be, in the meantime, I will appear before them, my lord.
We are not going to do anything. The Supreme Court says, and the Act says that keep your hands off.
Yes,
It is a very limited window for us.
yes,
We do that. We more often than not give some latitude to the borrowers.
yes.
But the purpose is to get back the money, to claw it back from you somewhere or the other. Otherwise, the whole edifice will crumble, no?
Lordship, the matter may be fixed on,
We are fixing it as we give a date always. As
23,
prayed
9.
for on behalf of the petitioner, re-notify on 12th.
Next week. 23/9. Oblige. Item 16.
Yes, yes.
May I please, your lordship?
Yes.
My lord, my case is that, my lordship, I was appointed as electrical engineer, my lordship.
You were appointed as
Electrician, my lordship.
electrician
Yes, my lord.
and you worked for 28 years.
Yes, my lord.
Yes.
That is my case. Long standing stagnation in my career, my lordship. The honorable judge has accepted, single judge has accepted that injustice has been done, my lordship. And if it is accepted, my lordship, there is no bar to issue writ of mandamus, my lordship.
It's a very
Writ of-
interesting argument that you have made.
Yes, my lord.
So many things that we see, but then we need to have a platform for us to pass an order. Correct? So is there any policy? The policy was in the contemplation of the government.
My lord.
It was never notified.
Yes, my lordship. They had the intention to give benefits to the,
What to do?
my lord.
How to issue a mandamus?
My lordship, the honorable single judge has accepted that unfair and injustice has been done, equality has not been maintained, my lord. If the honorable court, my lordship, has accepted this, my lordship, in absence of any rule, my lordship, that power the honorable court has, my lordship. Article 2226 gives that power, my lordship. Okay. And government's, my lordship, state respondent, my lordship, in absence of any specific rule, they have the under administrative power, they can issue directions, my lordship. I was appointed
Just a
in.
minute.
Mhm.
Yeah. The learned single judge was pretty perturbed by the fact that you have served for 28 years as an electrician.
Yes.
But he found no path to follow. We are also stuck up there.
My lord, the learned single judge has categorically
No, no, we
accepted
are
my
equally repeating what
grievance.
different single judges said, and we are also repeating in different ways.
Yes, my lord.
What to do? Can you show us? Can you take us to the garden path?
My lord.
Something in the contemplation of the government? Yes, Mr. Stick.
The learned
Mr. Nath, you have to do something for you. You have to be a model employer, no?
But that,
This
that,
is against service dues. And have you given them any monetary upliftment?
yes, yes, financial benefit they have got.
They've got financial.
Yes, yes. They, in the additional affidavit, we had stated, Lord, and that
What have you stated?
page 136.
Read that.
Lordship. She has received two financial benefits during her service till today. ACPS with effect from 1/1/2011 and MACPS with effect from 1/10/2017. Two benefits, financial benefits otherwise has been given.
So that's in situ promotion.
Lordship.
Don't worry.
My lordship, these financial benefits is regarding regularization of my service, my lordship. As an electrician,
Lashkar.
nothing else, my lord.
We have heard Sri S.B. Lashkar, learned advocate for the appellant, and Mr. D. Nath, learned senior government advocate. The appellant, who has remained on the post of electrician for approximately 28 years without getting any promotion, is aggrieved by the judgment impugned dated so-and-so, passed in so-and-so, whereby only an observation has been granted. Only an observation has been recorded that the appellant and persons similarly circumstanced have been put to great disadvantage because of the post of electrician not having been encadred and they not falling in any feeder cadre for promotion to higher posts, but refrained from giving any direction from notifying the Assam Technical Establishment Service Rules, which was formulated, approved by the Personnel Department, approved by the Personnel and Finance Department, but never notified. It appears that the appellant joined the post of electrician and continued on that post for a long time till today. Her experience and qualification, according to the appellant, gives her the entitlement to be promoted to the position of junior engineer electrical or assistant engineer electrical. The major contention of the appellant before the learned single judge was that when a draft rule under the rubric Assam Technician Establishment Service Rules had been formulated and there were administrative and financial approval, it should have been notified. The other contention of the appellant before the learned single judge was that Rule 28 of the Assam Engineering Public Works Department Service Rules 1978 also provide for relaxation of the rules in appropriate cases. The appellant, given her long-standing service as electrician since 1966, and she also possessing the qualification of Bachelor of Engineering in Electrical Engineering, the rules ought to have been relaxed for considering her promotion to the post of Assistant Engineer Electrical. The learned single judge, after having examined all the case laws which were cited, was of the view that since the post of electrician is admittedly an ex-cadre post, in the absence of any rules, promotion to the higher post could not have been given to the appellant. The observations of the Supreme Court in Tamil Nadu Administrative Service Officers Association and another versus Union of India and others, 2005 SCC 728, namely a direction to the union government to consider, in consultation with the state government concerned, as required in the cadre rules, and review the necessity of either to encadre the ex-cadre / temporary posts and take necessary steps. How have I begun the sentence? It was also taken into account, but the learned single judge found that those directions were issued under the special facts of the case, as certain posts in the state were earmarked to be manned by IS cadre. But the government had created some posts which were being continued for long and not in cadre, long but not in cadre. And therefore only IS cadre officers were eligible to be appointed on those posts. The case of the appellant was found to be different. It is tried that a promotion to higher rank can be considered only against rules and also from the feeder cadre, and not and such avenues would not be open to the appellant and others similarly situated whose posts are not encadred in the feeder cadre. While expressing, while not seriously opposing the concern shown by the learned single judge in allowing the appellant to stagnate for such a long time at one post, Mr. Nath, learned senior government advocate, has submitted that for the absence of any promotional avenue to the appellant, she was given 2 financial upgradation, which was more in the nature of, which was akin to and in the nature of in situ promotion. Taking these aspects into account, we do not find that the learned single judge we do not find that the order passed by that the judgment passed by the learned single judge needs any interference. It can only be observed that if the Assam Technical Establishment Service rules have been formulated, the government may consider notifying the same, to ease out the difficulties of the employees in its capacity as a model employer. However, finding no merit in this appeal, we dismiss it.
Highly obliged.
Item number 17.
Yes.
My lord, here in this case, my lord, charge against the petition appellant is that, my lord, one file, he is a grateful employee of a Munsif to Nalbari. One file has been missing from the courtroom. on that date, my lord. And consequent to which a disciplinary proceeding was initiated. And
Mr. Das,
Yes, my lord.
there is no finding that the file was misplaced deliberately,
yes,
right?
Yes, it was a negligence, my lord.
Negligence.
Yes.
So withholding of 3 increments, a peon, we are not talking about an officer, he's a peon.
with
And for his life,
cumulative effect.
for his life,
Yes.
is it not does it not shock your conscience? Our conscience are too fragile, we get shocked by
So
little
far as,
instances.
so far as proportionality is concerned, my lord, I leave it to your lordship. Lordship can take a call. But in fact, this is a minor penalty, my lord. And he has admitted during the course of the inquiry.
Can you consider, can we consider, not making it cumulative or not making it for
Lordship
the
can-
whole of his service
yes.
period?
Lordship can always consider. Lordship can always consider. Because perhaps disciplinary authority came to this conclusion because of finding recorded by the inquiry officer at para 15.
The whole plethora of precedents would tell us that don't substitute your opinion.
There are
But then
otherwise also, my lord.
Only in urgent cases, only in very, very few
Shocking.
cases which require interference because there has been a delay in conclusion of the departmental proceeding.
Correct.
That the opinion could be substituted. Otherwise, it has to go before the
Yes.
disciplinary authority.
Yes.
We don't do it on that. Take. Can undo that. Yes. You're Mr. S. Ghosh.
SK Ghosh.
SK. We have heard Sri S.K. Ghosh, learned advocate for the appellant. And Mr. H.K. Das for the high court.
2, 3, and 4.
Correspondence number 2, 3, and
4.
4. There were 2 employees who were put to departmental proceeding and subjected to same punishment.
Yes.
Where is the other one?
Other one, she has not filed any appeal. Maybe separate appeal. I have no.
Can you find out and tell us? No, we are
Yes.
not going to pass any order which would benefit her. Unless she comes here, we will not do that. Now, we are only contemplating was this fact would make us, scale back to some extent that we might, we are referring it to the department. By the impugned judgment passed by a learned single judge, the punishment imposed upon the appellant of withholding of 3 increments with cumulative effect for the remainder of his service tenure was not interfered with. Holding that this was not in the domain of the judicial review. It appears that the appellant, while serving as a peon in the court of Munsif number 2, Magistrate Nalbari, faced departmental proceeding with respect to an incident on 19/11/2019 when one of the files handled by him was later found to be missing. The appellant was served with a charge sheet alleging negligence in duty, which led to the disappearance of the court record. the disciplinary proceeding was concluded and the disciplinary authority by order dated 2/2/2021 imposed the punishment of withholding of free increments of the appellant with cumulative effect for the remainder of his service. The learned counsel for the appellant submits that the learned single judge did not consider that the punishment imposed upon the appellant was too severe, considering the misconduct / negligent performance of the duty of the appellant. Such punishment would permanently affect his pay and pensionary benefits. So that apart, the learned single judge, it has been argued, did not take into account that there was any deliberate inaction on the part of the appellant, or was there any finding on record about his regular reckless handling of files. It was a solitary incident where the appellant had left the premises only to find a record missing when he returned. The learned single judge has rightly relied upon the judgment of the Supreme Court in State Bank of India versus AGD Reddy, 2023, 14 SCC 391, wherein the scope of judicial review in disciplinary proceedings have been dealt with. There is no gainsaying that the scope of judicial review against a departmental proceeding is very limited, as this judicial review cannot be converted into a proceeding under appeal. And therefore, review of the decision of the disciplinary authority on merits would not be permissible. The scope of inquiry, the scope of judicial inquiry is only to examine whether the decision-making process was legitimate and for the purposes of ensuring that the findings are not without any evidence. If the records reveal that the findings of the disciplinary authority are based on some evidence, it would not be the function of the court in a judicial review to reappreciate the same and arrive at an independent finding on evidence. However, in the present case, we find that the learned single judge ought to have taken note of the disproportionality of the punishment imposed upon the appellant. True it is that during judicial inquiry, a court has to operate only within narrow limits. But if the judgment, if the punishment is found to be disproportionate, found to be shockingly disproportionate to the misconduct, there could be judicial interference. The earlier position of law, namely that the adequacy of the punishment is within the domain of the disciplinary authority, has undergone a change. The proportionality theory of punishment was invoked for the first time sometimes in the year 1983. But later, the theory was well recognized and enhanced in cases of Ranjit Thakur versus Union of India, 1987, 4 SCC 611, and Union of India versus G. Ganotham, 1997, 7 SCC 463. These judgments reflect that proportionality in punishment is a facet of Article 14 and requires interference by courts of law if it is outrageously disproportionate. The appellant served as a peon with no charge of being negligent in his tenure. Stop. A solitary incident where the record of one of the files went missing and the appellant, being the last person who was in charge of the records, ought to be seen in that perspective. I'll complete the sentence. Ought to be seen in that perspective. We do not find that we have not found any finding of the disciplinary authority that such missing of the file, such disappearance of the file was because of deliberate conduct of the appellant. Considering this aspect of the matter, we find that withholding of 3 increments with cumulative effect, and that also for the entire tenure of service of the appellant, is on the excessive side, the severity of which stirs us and goads us to set aside the impugned judgment and the punishment imposed upon the appellant by the disciplinary authority and upheld by the appellate authority. There is an appellate authority here also.
No appeal.
No appeal.
By the disciplinary authority, and remit the matter to the disciplinary authority for taking a fresh view on the issue of quantum of punishment. The decision by the disciplinary authority shall be taken within a period of 6 to 8 weeks to be counted from the date of receipt or the production of a copy of this judgment, of this order. Needless to say that the disciplinary authority shall give a hearing to the appellant and would not be bound by our observations. We order accordingly. We order accordingly. The appeal stands allowed to the extent indicated.
Much obliged. Deeply obliged.
Item 18.
Yeah. Notice.
Yes, sir.
Notice to so-and-so respondent. First paragraph. Notice to respondents on steps being taken, both modes returnable on
2017. Item number 19.
My lord.
Yes, one question was wrong, vague.
The question, because the translation of the English translation of the Indian Evidence Act,
Let's see what is that.
my lord,
Let's see the question and the translation.
question you will find, further, page 47. Yes, I mean, no.
Yes. So this is the question number 97.
97 below. That is in Assamese below.
Let me go by the translation of my brother.
My lord.
Yeah.
Evidence Act translation for the Assamese. Hmm?
So Indian Evidence Act 1832 or the new one? Yeah. इसके bracket में क्या? Where is the translation, Mr. Saraf?
Well, translation of the Evidence Act, no?
No. Question number 97, have you translated it in
Translated here,
English for one of the judges to understand?
My lord, my lord. Yes.
And I'll say for both the judges.
Yeah, we are seeing it. All copy na?
If there is even slightest hint that it concerns the Saksha, the name of today, then you have no case.
No, certainly below. Well, I'm sorry, my lord, the one copy they have taken a print out, below.
Under which section of Bharatiya Saksha the name to the time? This is really, and Indian Evidence Act, what do they say?
So the same translation you will also see, page 50. Mhm. Page 50, it starts, my lord.
Yeah.
52C.
Indian Evidence Act.
Yes, sir. At page 52, you will also see 52C. Page 52C, my lord. At the top, my lord. This is a gazetted copy, my lord.
Website.
If the year would have been mentioned, the thing would have been different.
No, that's right.
But, and the syllabus also, my lord, it mentions both the act, Indian Evidence Act.
Just a minute, let us see.
My lord.
Now, in the Dying Declaration in 1872, I remember it is 32.
32.
32.
Yes.
And in the other?
Others?
26.
26. 26.
That is option A and B. B, they have taken C as right answer, whether A is also right.
But the examination was being held after the enactment of the Bharatiya Saksha Adhiniyam. So you should have understood, and all the other students have marked accordingly.
No, my lord, because we don't know, because 74.
You really
75.
don't know, but whether we
My lord,
reopen it.
My lord, the syllabus, my lord, both Evidence Act as well as Bhasa Sabche, both were mentioned. You'll also see the syllabus. Page 25.
What is the stage of examination? Mains
Lord,
is over.
No,
Mains is
main
not
is not
over,
yet.
only preliminary, my lord. And I secured 74, 75 was the cutoff mark. And if I get the 75, I will be able to sit in the final examination, that's all.
No, it's not that's all. If we do that, we'll be tinkering with the examination
No, my
process,
lord,
but let's see.
my lord, I may just,
Mr.
My lord.
I may just show you.
Mr. Mahanta, you have to tell us.
My lord,
Now,
once,
case law we are aware of.
Page
In fact,
25.
only recently before coming here, I have delivered a judgment with respect to Bihar Public Service Commission preliminary examination, where many other challenges were thrown apart from this. I did not interfere and the judgment was upheld. But then the law remains law.
Well, Joshi Mr. See page 25, my lord. Let us know question answer about English.
40.
Page number.
That what he says, that it is vague.
Yes,
I am
36. Yes, number 36.
That is only
There's no vote.
Yes, Mr. Mahanta, both
Yes.
Evidence Act 1872 and the new act was in the syllabus.
My lord.
And you don't mention the year.
Yes, my lord, the area is not mentioned in
So
translation
therefore it
version.
is vague.
Actually,
So,
my lord,
so the judgment, which judgment
no, my lord, your lordship,
covers his case? Richal.
but my lord, there is a judgment, my lord, of the apex court that, my lord, when there is a two view is possible, then you have to admit the view of the examining authority, my lord.
Any examining, there is no dispute about that. That can't be.
Because, no, there
Mr. Manda, don't misread that judgment. That judgment says that if there are two views on interpretation, then the view by the expert has to be accepted.
my lord,
Here the question is that the question was wrong.
yes, my lord,
So the question is patently wrong.
no,
You see, look at this. I have found out.
I'll try to find out, my lord.
Yeah,
But problem is that, my lord, your lordship kindly see, then on the basis of that, my lord, answer key, all are evaluated.
Rishal versus versus Rajasthan Public Service Commission.
My
You have got the judgment?
I've got one Delhi High Court, my lord. But you're asking me just see, my lord.
Delhi High Court, we are looking at Supreme Court judgment.
My lord, I must say, my lord, that the case, because generally I don't deal with such cases. At page 36, you're asking me, see, my lord.
The most important case here is Ranvijay Singh versus State of Union.
I will look into it, my lord.
But Rishal is with respect to vague question.
Ranvijay is yes, my lord. That
My lord, you're asking,
Ranvijay we know.
Ranvijay,
my lord,
Ranvijay doesn't cover his case.
my lord,
Rishal.
my lord.
lordship, just see, my lord, page 36, my lord, once.
So many others. She doesn't know.
Question number 30, my lord.
Hmm.
30A.
Yes.
It gives both Indian Evidence Act and Bharatiya Sakshi Niyam, Adhiniyam. Then also further see, my lord, next page, page 35.
No, this is for what purpose? That
But I'm showing, my lord, that they have taken both.
now by reverse logic, if they have not taken both, then the current one.
My lord, current one, then they must have mentioned the year, my lord.
The year was not mentioned.
Otherwise, my lord, how?
They mention year, where is the vagueness?
No, if the year would have
If they
been.
mention the year, where is the vagueness, Mr. Sharaf? That is
No, that's correct, my lord. My lord, if
that's understood.
my lord, if I mention like the 26, and if they take it that no, we have taken to Indian evidence, my lord, how I know?
That's therefore we say that it's vague. It immediately attracts our attention.
Vagueness, the benefit, my lord, and this is only for, my lord, competing in the final examination, only cutoff date, cutoff number.
Mr. Manta, find out what can be done. We don't want to upset the
No,
apple
actually,
cart.
there is your lordship kindly see on the same, my lord, we have to apply the same yardstick in case of other student also. On the
I
basis of the,
objected.
my lord, answer key, only on the basis of the official answer key, we have evaluated the, now, my lord, your lordship,
But we are not asking you to concede, but the question is absolutely vague.
my lord, that is
And
true,
the
my lord.
answer
That is,
in
that
both
is,
the
that is
statutes-
admitted, my lord.
In the list of answers, the correct answer in both the statute is there.
No, my lord,
Suppose if वो देखें भारतीय साक्ष्य अधिनियम में there was 26 अगर होगा नहीं होगा then
only, my lord, year was not mentioned, that is why, my lord, otherwise, same, my lord, Assamese translation version is both same, my lord.
That I give you a gazette report.
Yes, gazette report. Option A and option C both are correct, my lord, in that point of view.
Then therefore it's vague. No.
Yes, my lord, that is ambiguity is there, my lord. That is correct.
This is 26. Exact reproduction of 32.
My lord,
How would he have known?
my lord.
How would he have known? How would the applicant have known?
Yes, my lord, that is true, my
So
lord.
therefore, one mark is admissible to her, and then she crosses that threshold.
Yes, my lord.
Are you interested without any difficulty? Are you allowing her to pass? Find your ask your chairman of the Public Service Commission. Sam Public Service Commission.
No, my lord. This is
It's a high court.
High court. So then we have to recast the entire, my lord, prelims result.
No, when the draft was published, I raised the objection also that ANC.
Mr. Sharaf, you are treading in a difficult territory. Now, if we decide that don't mark that question.
My lord, in the question, my lord,
Don't mark that question. So others may compete, but you will not because you will come down to 70. I don't know, you will remain at 74.
74. And this is not a final examination, my lord.
And nobody else has questioned this.
No. And I raised the objection. I raised the objection at the time, my lord. I'm sorry.
when the draft was published, I raised the objection.
Yes,
But that has not been
This,
considered.
this cannot be ignored. You have to find
Yes,
out how
my lord.
can it be resolved, Mr. Manta.
My lord, that will be actually, it will be big problem otherwise, my lord. Because,
No, no, your problem doesn't mean anything. The problem. the
no, that is
problem of-
ambiguity is
just a
there,
minute, the problem of the High Court vis-a-vis the problem of the applicant.
my lord.
The applicant gets one opportunity to test, to get her merit tested, his merit tested, he or she. Her merit tested. A vague question, and why did you not why did you not respond to the objection?
I raised, my lord.
My lord, that was turned down. I don't know, my lord, what reason that is turned down. In aspect of others, my lord, there is two questions, my lord. Page 57, your lordship kindly see.
Not many candidates would have appeared. Not many candidates would have appeared in this, no?
Probably, my lord, how many
Find out from
candidates?
the records of the examination.
My lord, I have to verify, my lord. How many
And just
candidates?
tell us whether without upsetting the apple cart, if something can be done. Prima facie, it is vague.
Yeah, absolutely, my lord. I agree, my lord. Absolutely, my lord. There is, my lord, both the.
If you agree to this, Mr. Mahanta, tell us how to resolve this.
That is why, my lord, I have to
Take instructions,
my lord.
get back to us by Friday.
My lord, I'm just saying, 74 marks secured candidates as 14. Now, we don't know that whether for this mark, the answer was
We
there.
will have it verified.
Verified.
If you are put to a specific disadvantage, only then we'll allow. Now, let's see how it has been marked, how many persons marked, how many are left.
Yeah, how many years attempted?
Recomputation will require what? We can't do like this, no? Otherwise, one petition of yours, it'll open a floodgate for hundreds of petitions.
But, my lord, the question will be there, subject to submission.
We understand. The logic we understand. You are concerned with you.
But, my lord, the question that.
We are concerned with you and others.
And I fully appreciate, my lord, that if it would have been a final
Find out
examination.
and tell us, Mr. Manta, how
My
to
lord.
resolve this.
My lord.
One question and you
One
failed
question.
to mention the year. You should have,
Yes, my lord.
removed this 26 from the answer or 32 from the answer.
In fact, in the course, it should not have been given at all because 72 is not there now.
No. The only thing without the year, the only thing, if that question was framed without giving the year of the
Yes,
enactment of the statute,
My lord,
the only way in which you could have saved that question was not to give one of the correct answers as a choice. 32, everybody, even a beginner would remember under the Indian
32, Gain declaration 32, my lord, as per earlier act, that is correct. And then as per new act, my lord, option C, my lord, that is
correct.
26.
And you don't state the, and in the syllabus, both the.
Both act, yes, my
So
lord.
therefore, where is Mr. Saraf wrong?
No.
That your question was vague.
Well, page 37 also. So
You don't respond any
correct,
further.
my lord.
no. I just.
Now, how to solve the problem?
Argument now.
No, my lord, I don't, no, not on that.
We are contemplating how to resolve this.
Yes, my lord, exactly.
But they have also mentioned both, if you lordship, just see page 37 for my.
I have seen that.
Page 37,
Yes.
question number 35.
Mr.
My lord, I'll take instruction,
Look
yes.
at this. Look at page 37. He's right. Side by side, you're asking questions. There is no difficulty, but then these are the loopholes which the candidates look for when they fail.
My lord.
I'm not failed, my lord.
Find out how can it be resolved,
My-
otherwise we'll have to do something.
My lord. Because
Fortunately, it is only High Court and not many persons would have applied.
I'll find it out how many applied and how many attempted the question.
How many applicants, what is
My
the
lord,
number?
details I'll take.
See, I'll tell you I can tell you my experience. Now, I was sitting in a roster where all these matters cropped up. So many a times I interfered, changed the results, especially with respect to High Court appointment, additional judges, district judges. Some of it were affirmed by the Supreme Court, some of it were turned down and rejected. So we are at crossroads. We have to see whether we cannot ignore this argument.
My lord.
Prima facie, it appears to
My
us
lord.
to be correct. How to resolve this?
And, my lord, the subject of
It
final.
doesn't require any legal grounding. You
My
have to
lord.
tell us practicality. you have to
Practically,
tell
my
us
lord, how to
resolve.
solve the problem, my lord.
Take
My lord.
the petitioner could not cross the threshold of preliminary examination of Assam Judicial Service grade 3 2025 for having obtained 74 marks whereas the cutoff in that category, in that category was 75. The grievance of the petitioner is that one of the questions was vague. One of the questions, namely question number 97, was vague. In the syllabus, both Indian Evidence Act 1872 and Bharatiya Sakshya Adhiniyam 2023 are mentioned. So the question pertained to the provision concerning dying declaration. The question in Assamese read as, which provision under the Bharatiya Sakshya Adhiniyam, which is the equivalent English translation of Indian Evidence Act as well, which is the equivalent in the translation of in the Indian Evidence Act also. Now we have the which section under the Bharatiya so Act contains the provision for dying declaration. So in the column of answers, section 26 bracket में BNS उसको हम tick करते हैं BNS and section 32 Indian Evidence Act, both were given. The petitioner appears to have ticked the correct answer for Indian Evidence Act. So the contention of Mr. Saraflan, senior advocate appearing for the petitioner, is that without mentioning the year of enactment of the statute, it could have been misunderstood either ways. Namely, whether the question was asked from Indian Evidence Act 1872 or from Bharatiya Sakshya Adhiniyam 2023. Mr. Mohanta, learned counsel for the High Court, learned senior advocate for the High Court, seek some time to take instructions in the matter as to how to resolve this aporia, how to resolve the issue. All
I'm obliged.
re-notify on. Next week, your mains is beginning from when?
24th October.
So this month only you have to tell us. Pilot. Today is what, 15th? Tell us on 19th. What can be done? Because this question can't escape our attention. No matter, this institution would suffer.
Exactly.
Suffer, but what to do?
Let it be on
Sitting in the judicial side, we don't care who the organization is.
Can it be on 22, my lord?
22, yes. My lord. Don't come up with problems.
No.
Tell us the solution.
My lord. My lord.
All right.
Item number 20.
My lord, in this case, my lord, the affidavit is ready. I am going to file today, my lord.
All right. As prayed for on behalf of Mr. Mohanta, learned senior advocate. On behalf, as prayed by Mr. Mohanta, learned senior advocate. On behalf of the respondents, re-notify next week. We'll give a copy to him.
My lord.
You go through it. In case you need to rejoin, you may do so before that date. We are giving you 1 week.
23-9.
We'll get up. We'll come back in 5 minutes.
Item 22.
Yes, Mr.
It is your lordship. My lord, the grievance of the appellant before lordship in this writ petition was that.
Louder, sir, louder.
My lord, grievance of the my lord appellant before the writ petition in the writ petition was that, my lord, he was appointed by the school managing committee in 1987, and when in 2013 the school was provincialized, he was left out. Then, my lord, he approached this honorable court. Honorable court directed that his case may be considered in terms of the new act. In the meantime, my lord, new act has come. On that basis, my lord, the authorities, the Director of Education has passed an order
29/7.
my lord, rejecting my claim, notwithstanding the fact that, my lord, the rules require that, my lord, it has to be scrutinized by a committee. And
Let us see where is the rejection order.
earlier order, my lord.
The order which you challenged before the writ court.
That order, your lordship will find at page 43. The name of the petitioner Nilakanta was recommended by the DSC Dhemaji for provincialization of service as per Act of 2011.
Where are you reading? Yeah, the first line.
After the chart, my lord. The name of the petitioner Nilakanta Chutia, he is the, my lord, appellant, was not recommended by the DSC Dhemaji for provincialization of service as per Act of 2011 as amended in 2012. After receiving the proposal from the BEO Dhemaji, this office placed the matter before the SLSC, and accordingly SLSC recommended the above mentioned teaching and non-teaching staff of the state school, and this office submitted the proposal to the government for creation of posts. Accordingly, government sanctioned post-wide letter number such and such dated 22/11/2013 enclosing a list of vacant posts of UP schools in which the science teacher post is shown vacant against Beverly Adarsha ME School, and this office issued provincialization order white memo number such and such. Being aggrieved, the petitioner Nilakanta Chutia filed a writ petition in WPC number such and such before the Honorable High Court. The Honorable Court passed an order dated 21/3/2018 in WPC 898 of 2014 with a direction that the respondent authorities may consider the case of the provincialization of the petitioner under section 13(6) of the Act of 2017. If otherwise the petitioner is eligible. As the Assam Venture Education Institution Provincial of Services Act 2011 has been declared ultra virus by the division bench in WPC such and such, that is such and such. In view of the above facts and circumstances of the DSC, Dhemaji has not recommended the name of Nilakanta Sutia for provincialization of service as per Act of 2011 as amended in 2012. On the other hand, all the other posts of assistant teachers in Beverly Adarsha ME School were provincialized.
Things.
My lord.
Now, did you challenge the decision of the state level scrutiny committee, which did not recommend your name, or you are asking for your name to be recommended against a vacant science teacher's
No, my
post?
lord. My prayer was that, my lord, as per the new act, because 2011 has gone by, new act provides for, my lord, consideration by committee.
Whichever was recommended.
No, my lord.
13(6) says what?
It is fresh, my lord. If your lordship kindly comes to the provision of the act. My lord, that is, my lord, section 13.
Page? Yeah, act.
In the book. Page 120 is the section 13. 120.
उसके बाद ठीक है you're not in a hurry. Which page?
Page 120, that is section 13. District Scrutiny Committee and State Level Scrutiny Committee. Your lordship may skip, my lord, come to subsection 6. The district scrutiny, may I read it, my lord?
Yes.
The District Scrutiny Committee shall first scrutinize and prepare a list of all venture educational institutions within the district which are eligible in terms of the provisions of this act, and shall thereafter proceed to scrutinize and verify the service records of all the serving teachers who are eligible or would become eligible for being considered for provincialization of their services. The district committee shall identify a base school.
This is the difficulty, no?
Well,
now they have only one post vacant for science teacher, and the base school is not the school where you are employed by this school management committee. That's the whole difficulty.
My lord, the question here is, my lord, even after the, my lord, district, because
let's see what was your prayer before the learned single judge. We are reading at your petition memo of appeal. It appears that you are wanting a place in the list where your services would be provincialized.
But the difficulty is that in the erstwhile rule also, you were not, even in the later one, you were never recommended by the district committee.
No, in the later one, my lord, after
Let's see the impugned judgment.
impugned judgment, your lordship will find, my lord, at page, it starts at page 107. May I take your lordship to the, my lord?
1 second.
My lord. Page 111, my lord.
Just a minute, 1 second.
My lord, I'm sorry.
If otherwise he is available. The document दिखाया your rejection था, वो rejection था, और ये rejection है, it was 43, and it's justified. So इसमें what is the reason given for non-consideration by the BSc? वो देखिए, देखो इसमें, हाँ, तो consider करने लगे, consider करने के लिए उसका क्या 13 से 13, हाँ, तो 13 कुछ किया मतलब 13(6) वाला वो ऑर्डर में नहीं किया, नहीं ये how do you because the director 13(6) began maybe phase 120. Phase 120. Phase 120. Districts should be split within. And what the judges said.
Let us see what the single judge has said.
My lord, the finding of the honorable single judge, your lordship will find that paragraph 14, page 111. Where, my lord, two mistakes have been committed, my lord.
It's 14.
Paragraph 14. May I read paragraph 14, my lord?
Yes.
It is true that as per section 13(6) of the Assam Education Provincial Service Act 2017, for consideration for provincialization of the school and the service of the employees are to be placed before this district scrutiny committee. However,
No, this paragraph 14. No, this can't go. Yes. No, this can't go. Because some other authority has decided. We can't decide it. The director could not have decided it. The statutory body which is entrusted to decide is a state level or district level scrutiny committee. So this justification by the learned single judge is incorrect. What do you have to say?
If you lordship peruse, my lord. Page, my lord, 12, my lord. Though they have annexed.
Page 12 of what?
Page 12 of judgment, my lord. 113, my lord.
Tell us the paragraph.
Para 12, my lord. Though they have annexed the order of the DSA, my lord, but they have not argued on that, my lord.
Let them not argue. This is an appeal.
Yeah.
No, my
Let
lord,
that not be from through the mouth of Mr. M.K. Chaudhary.
No, my lord, before the single judge, my lord.
Even then we find this justification to be incorrect.
and
Do you need to would you respond or will pass not?
in fact,
No,
director
we have a file our affidavit, my lord. My lord, if you lordship peruse new act, my lord, 3/111, my
She
lord.
will pass that. You have filed your affidavit.
My lord.
No, here you want to respond to this.
No, my
We are
lord.
inclined.
We have already
Just
filed.
please listen to the court
My
first.
lord.
No, we are not in a position to approve of the reasoning given by the learned single judge in para 14. He may or may not have his case. He may not be provincialized, but this reasoning is incorrect. We'll turn it down. Prima facie, unless you justify it.
My lord,
Would you like to place your opposition affidavit in opposition?
My
we have
lord.
filed, my lord.
Already filed.
You have filed it.
My lord.
Yes. What do you have to say?
That this point was not argued. That is the, my lord, only thing.
No, this we may not. Where have you said so? This point was not argued.
No, not point, my lord. Though they have annexed the, my lord, order of the DC, my lord, but they have not argued on that, my lord. My lord, if you lordship peruse, my lord.
Would it make any difference, Madam Counsel?
Because my lord, as per section 3111,
Question
my
is
lord,
whether you argue or he argues. If the act provides that this matter has to be decided by the state level or district level scrutiny committee, can it be usurped by the director?
no, my lord.
It can't be. And what was the order passed by the learned single judge in the first instance when the matter had to be decided by the state level committee?
My lord, that your lordship peruse page 101, my lord.
101.
101, my lord. In that case, my lord, the petitioner has challenges the promotion of some other person, my lord. Page 101, my lord, last paragraph.
No, no, we want a high court. Okay. Then. Your.
101 নহয়, পেজটো ভুল হৈছে কিবা।
101 আছে।
99 হ'ব নেকি? 101 99 হৈছে মোৰ পেজত। Configuration ভুল হৈছে 101 নেকি? 99 মোৰ তাত 101 ওলাইছে নেকি? কথা কি আছে কিবা? ফাইলিং ভুল হৈছে।
The order take. The respondent authority. This was the respondent authority, the director must have been the party. No, and the state legal committee or whatever.
But here is the. 113.
Under section 30.
And the last line, my lord, if otherwise the petitioner is eligible, my lord. The petitioner is not eligible, my lord.
That question you can raise.
My lord.
How?
Because my lord, as per 3111, my lord, only 3 teachers, my lord. Science teacher post is available, my lord. He is not a science person, my lord. He is SS pass, my lord. If your lordship peruse 3111.
I didn't follow what the argument you made.
If your lordship followed new act, my lord, 2070 3111, my lord. As per 3111.
Can you speak a bit slowly?
My lord.
Volume decibel should remain the same, but slowly. I don't follow what you're saying.
My lord, as per new act, my lord, 3111, my lord.
3111.
My lord.
Yeah.
The provision is only for 3 teachers, my lord. So science, mathematics, and social.
Science, mathematics, 311. Where is that provision?
Page 111, my lord. One is in case of Hansard Primary School, my lord, there.
Which provision see, you're addressing a bench,
my lord.
One of which is not aware of this provincialization concept. So you have to go a bit slow, no?
My lord,
Otherwise we'll allow the petition. Now you have to. There's no problem with you. Your way of arguing is very good, but the problem is here. I need to understand. Yes. Which provision?
3111, my lord, Roman 11.
In case of venture upper primary school, there shall be minimum. There shall be minimum 3 teachers that teaches at least 1 teacher each for science and mathematics and social studies. And what subject is he from?
He's from, my lord, SS pass, my lord. He's SS high secondary pass, my lord.
ME school. ME school.
Mathematics, social studies, science and mathematics. Subject wise, higher secondary pass is something classification.
My lord.
We want whether he was a teacher, whether he was appointed as a teacher for science and mathematics or social studies or languages. I think all subjects will be covered under this, no? Social studies would include history, geography, civics. It's a very broad classification. And therefore, this aspect had to be seen by the district level scrutiny committee. The director would not know it. Correct? Now, any other argument that you want? No, we are not deciding anything. We are not asking you to provincialize the service. We are remitting the matter to the authority which needs to decide. Correct? Or take up.
There was another mistake, my lord, in the paragraph 14 judgment that, my lord, I have not challenged the order that I have challenged, my lord. If your lordship reads paragraph,
That we don't take notice of.
my lord.
We find the reasoning in paragraph 14 of the interim judgment to be incorrect. We are upturning it. Take up. Again, we have heard Sri M.K. Chaudhary, learned senior advocate for the appellant, and
S. Sutyamai,
S. Sutia for the
elementary division.
correspondent number?
All the respondents.
For all the for the respondent. For the respondents. The appellant had approached this court for a direction to the respondent authorities to place his case before the district scrutiny committee, bracket DSC, hereinafter referred to as DSC, Dhemaji, in terms of section 13, bracket 6 of the Assam Education, bracket provincialization of services of teachers and reorganization of educational institutions, bracket close, Act 2017, for consideration for provincialization of his service as assistant teacher in Bhebeli Adarsh ME School, Dhemaji. It may not be out of place here in this context to mention that earlier the appellant had approached this court by WPC number 898 of 2024 for a different relief, namely for his being made the headmaster of the school in question. The claim of the appellant is that he was appointed as an assistant teacher in Bhaveli Adarsh ME School in Dhemaji district on 15/2/1987, as per the resolution of the managing committee dated 12/12/1986. His name figured in the list prepared after the inspection of the school was undertaken as an assistant teacher at serial number 5 in order of seniority. Despite this, the post of the headmaster, the charge of the headmaster was given to a person who was junior to him in seniority. In seniority. Perhaps after the earlier provincialization seniority. Stop. In that context, come on. on finding that the junior person who was given the charge of headmaster had served for the last 20 years, the court directed that for the purposes of provincialization, the case of the appellant be considered by the respondent authorities under section 13 bracket 6 of the Act of 2017. And if 17, provided the appellant was eligible for the same. It appears that section 13, page number
100. That 120, it starts with and relative and pieces then.
It appears that section 13 bracket 6 of the Assam Education bracket Provincialization of Services of Teachers and Reorganization of Educational Institutions bracket close Act 2017, hereinafter called as Act of 2017, provides that that for the purposes of provincialization, the district scrutiny committee shall first scrutinize and prepare a list of all venture educational institutions within the district, which are eligible in terms of the provisions of the Act, and shall thereafter proceed to scrutinize and verify the service records of all the serving teachers, who are eligible or would become eligible for being considered for provincialization of their services. The district committee shall identify a base school for each category of school and recommend the name of teacher/tutor to be associated against each base school. Thus, the authority which was required to consider the entitlement of a serving teacher for his services to be provincialized is the district scrutiny committee and not the director of the education, not the director of the education, director of elementary education. Pursuant to the order referred to above, passed in WPC number 898 of 2014, referred to above, the matter was taken up, but only by the director of elementary education and not by the district scrutiny committee. A perusal of the order passed by the director indicates that the case of the petitioner was rejected as his name was not recommended for provincialization of services as per the Act of 2011 as amended in 2012 by the DSC, by the District Scrutiny Committee, bracket for DSC. It was found by the director that all other posts of assistant teachers of Haveli Adarsh ME School were provincialized, except the science teacher's post as per the Act of 2011 as amended in 2012. The appellant was appointed by the school management committee as assistant teacher in the school, and therefore his services cannot be absorbed as a science teacher which is lying vacant. it was solely on that ground that the claim of the appellant was rejected. This order was passed on 9th of August 2022, which was challenged by the appellant before this court by WPC number so and so. The learned single judge, by this judgment dated 19/3/2025, though took note of the fact that under section 13(6) of the Act of 2017, the consideration for provincialization of the schools and the services of employees are required to be placed before the district scrutiny committee, but held that since the consideration was made in its proper perspective by the director elementary education himself, comma, the requirement of the consideration was fulfilled, and since the name of the appellant was not recommended against the post of teachers earmarked for the base school, that is the school in which the appellant was appointed, comma, his services could not have been provincialized. The sole contention of the appellant here against the impugned judgment is that the statutory requirement under the Act of 2017 could not have been waived, even though the DSC or the state level scrutiny committee would come to the same conclusion, comma, the requirement under the statute has not been followed, and therefore the order passed by the elementary, therefore the order passed by the director of elementary education should not have been upheld. MS so-and-so learned counsel for the respondents, however, has submitted that the appellant would not be eligible for being considered, as there is no clarity with respect to his appointment. Namely, whether he was appointed as a science or maths teacher, or as a teacher for social sciences, or or something like page kitna?
Language.
And languages. The learned counsel for the appellant has submitted that such categorization of the posts of teachers was wide enough to include the case of the appellant as well. Without going into the aforenoted question, we find that the reasoning given by the learned single judge in holding that the decision by the director of elementary education would suffice if the decision has been taken in correct perspective does not appeal to reason. If a provision has been made in the statute, comma, it has not to be rendered irrelevant or obtuse by not resorting to the same procedure and coming to a conclusion which is adverse to the prospects of the appellant. For the aforenoted reason, we are inclined to and set aside the order dated so-and-so passed by the Director of Elementary Education, as also the impugned judgment in order justifying and upholding the same. The matter is remitted to the state, the case of the appellant is remitted to the district scrutiny committee, Dhemaji, for taking a fresh decision about the entitlement of the appellant
for being provincialized, for his services to be provincialized. Such a decision shall be taken by the DSC within a period of 8 weeks from the date of receipt or production of a copy of this judgment. The appeal stands allowed to the extent indicated.
Highly obliged.
Item 23,
Maybe the lordship.
You have mentioned, you have filed an affidavit, no?
Well, I have not, lordship.
Lordship, I have filed affidavit, your lordship.
It's not on record.
No, your lordship.
So we pass it over? Only pass it over or next week?
Lordship, next week, your lordship.
As prayed for on behalf of the respondent. Number 6.
Respondent number 2, respondent number 7 has filed, your lordship.
As prayed for on behalf of respondent number 7, let this matter come up to consideration on
24-9.
All right.
कितना number था ये?
Item 24,
33.
Yes.
No affidavit has been filed by the respondent.
Lordship, we have filed affidavit in the writ petition, my lord. We will the same, my lord.
Okay. Yes.
Lordship, I have prepared a note sheet to assist my lord mayor.
That's very kind of you. It only facilitates our work.
By this appeal, my lord, I
One
have,
second.
my lord.
For the purpose of pension, it has to be absorbed on or before 31/3/1970. What is the date of your absorption in the state?
1/77, my lord.
That's after the cutoff date.
My lord.
So therefore, your claims would be considered, but only with respect to seniority, pay and leave, with respect to the services which you rendered in the government before, in the organization before the absorption.
But my ground number 3, my lord,
the circular cannot, my lord, override the rules, my lord. Pension rules, my lord. Rule 98, my lord, is clearly stated, my lord, which is amended in the year 2005, my lord.
No, no. No, 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 no. That's the same. That's
Page 15. Page 15.
internal.
Page 15, internal page.
He is Muhammad Hussain Ali.
98.
Yes, Mr. Chaudhary.
Yes, my lord. Madam, your worship kindly go to the memorandum of understanding, my lord.
Give us 1 minute.
My lord, my lord,
Whatever you argued in the first half.
my lord, my lord.
Yes,
Your worship, not 1 minute, my lord, more than the hours. Petition.
What is happening in Nagaon burn unit? There is no separate hospital.
No, no, they are, my lord.
They are continuing.
Yeah.
to our information, my lord, subject to what my lord.
No, my lord, that has also been because it was there in the Nagaon Civil Hospital. Now, my lord, that has been a new medical college hospital has come in Nagaon, my lord. So that is also not in.
That has also been discounted.
No, yes, my lord.
Okay.
Yes. MOU, where is the MOU? Mr. Bora,
Yes, my lord.
otherwise we would not have found any reason to interfere. But for the clauses in the memorandum of understanding, MOU.
Yes, my lord.
Now come to
Page
clause
43. 43.
Come to clause 2. Page 41.
Very
Read the first line, the pilot project so and so.
41.
And then the last two lines, in the state of Assam, Guwahati Medical College along with Nagaon and Dhubri districts have been identified under the project. On successful completion of the project, the aforesaid activities will become part of a regular scheme, and its coverage in terms of states and institutions will be subsequently extended. Right?
Yes.
And then come to clause 8. The state government hereby undertakes that it will take over the responsibility for maintaining the Burns Hospital Department after the end of 11th 5-year plan, that is 31/3/2012. And then 8.2 and 8.3. How do you come out of this, promise that you made under the memorandum of understanding?
My lord, the petitioners, appellants were initially appointed by
We
the.
have followed that. It is a state health society, not the hospital, not the Department
Yes,
of
ma'am.
Health.
Yes.
We understand that.
Yes, my lord.
But this was an MOU. Of course, it was a pilot project, but you had made a promise.
Yes, my lord.
And the promise was loud and clear. How do you get away from this? Only because it was done by society. You can't say that they were not
No, my lord.
regularly appointed.
Subsequently, my lord, everything has got changed because they were under the Dhubri Civil Hospital.
Where is
And Dhubri Civil Hospital has been dismantled, my lord. That is no more in existence, my lord.
Mr. Bora, we don't need any repetition. We understand that it has been dismantled. Now new medical hospitals have come
Yes,
up
my
at
lord.
Nagaon and
And
Dhubri.
new appointment.
We have
procedure
followed
is-
that.
New selection process.
Did you make this clear in the understanding in the MOU that once the hospitals would be done, on the other hand, you say that the undertakes that will take over the responsibility of maintaining.
So therefore, the takeover is by constructing a hospital, full-fledged hospital. So why can't you give them, why can't you accommodate them? Merely because it was done by society. But you were one of these stakeholders, no?
No, my lord, not only because of that, my lord, because subsequently the establishment where they were appointed, my lord, that is no more in existence. That has been dismantled, my lord.
You're not looking at clause 8.
Yes, my lord. 343.
Otherwise also, the moment it is extended to government organizations or the government takes over, whether a hospital is created or not, it has to be extended. Therefore, this gives them a legitimate expectation, no?
But when that particular unit is not there, my lord, scheme is not there, my lord.
Mr.
I understand, my lord.
That's
I
a very
understand, my
easy
lord. but-
argument for you to make. Not very easy for us to accept and dispose of this petition. State shall create regular posts against sanctioned contractual positions so that at the end of necessary posts exist for a smooth continuation of burn care services. The officials to be engaged on contract basis initially shall be engaged only if they are found eligible. Have you said that they are ineligible? They can't. Mr. Advocate General, good that you came here.
Lordship, identical case had taken place for Lakhimpur. We had a litigation, Lordship. I have argued that matter. If Lordship takes up some other time, I can praise because the identical case. Here, the employees, these are recruited or engaged. Now, I should not use the word recruitment. Engaged by the Hospital Management Society.
Facets of
that is a facet. So if the hospital has been upgraded from district hospital to the state, their services will be required and their status will remain same. Because in Guwahati Medical College also, we have the identical Hospital Management Society. In Lakhimpur also.
No difficulty.
No difficulty.
Unless if this clause 8 in its entirety were not there in MOU, we would not have questioned you even for a minute. We would not have detained you even for a minute.
The state government shall take
And
over
therefore, all this was advertised under the MOU. The society itself is not in existence, agreed, but the state is in existence.
Yes, Lordship.
So this is what happens to this. Unless you had come out with a resolution that no, that process of selection we will appoint afresh.
Here, it is regarding the responsibility of maintaining the burn department.
That's true. 8.3. Come, sir. Come to it. The entire 8 has to be seen.
Yes. A state shall create regular posts against sanctioned contractual position.
Mr. AG.
Yes, Lord.
This requires your.
We'll do, Lord. We, if they are trained persons, we always will require them.
So please.
Only thing is that they have to come to a proper recruitment process, not automatic regularization.
That's right.
That is the only condition.
Have you opened that window for them?
Lordship, I'll have to get the up-to-date status.
Please. You please look into it. We will want your assistance.
Yes, Lord. No difficult.
Mr.
Because
Bora
if they are trained.
Mr. Bora has done his job. Let him not feel diffident on any account. But Advocate General will take care of this matter.
Absolutely, Lordship. No issues because the burn unit, if it is going to be functioning, their services and their experience will be very much essential. Provided they come under the normal eligibility criteria.
Not, Mr. Advocate General, then we don't have anything to say. Is that you make a statement, we will dispose of this position.
Let me get the up-to-date status, then I'll make my submission. If Lordship is pleased to take the matter on Friday, by that time I'll get the up-to-date status.
Okay. Can it go on 23rd or 24th?
24th, Lordship.
How many matters are there? This is 23, 24 and 25.
24,
25,
Monday.
26 and 27.
24 Wednesday, no? September.
Wednesday.
Only 25.
26 and 27. Not help. 2 weeks आते तुम अच्छा 26 and 27. Okay. Take up. We have heard Sri Acharya Chaudhary, senior advocate, learned senior advocate for the appellants, and Mr. Bora for the state. In the year 2000, a memorandum of understanding was executed between the Ministry of Health and Family Welfare, Government of India, and the Government of Assam for the implementation of national program for prevention and management of burn injuries. The objective of this national program was to establish adequate treatment facilities for burn injuries, especially in district level hospitals and their peripheral healthcare institutions. Under the terms of this program, one medical college and 2 adjacent districts in 3 states were selected initially for implementation. In the state of Assam, Guwahati Medical College was selected as the main center, with Nagaon and Dhubri districts as peripheral units to be covered under the project. Pursuant to this memorandum of understanding the Joint Director of Dhubri Civil Hospital and Deputy Commissioner of Dhubri District, acting as the Chairman of the Hospital Management Society of Dhubri Civil Hospital, jointly issued advertisements inviting applications for various contractual posts to run the burn unit at Dhubri Civil Hospital. The appellants had applied and had participated in the selection process and were duly selected and appointed against different posts and started rendering services in the burn unit. Later, Dhubri Medical College and Hospital was established. The Dhubri Civil Hospital was closed down and the building was dismantled. The services which were being provided by the erstwhile Civil Hospital are now being provided by the Dhubri Medical College and Hospital in a better and efficient manner. The court has also been informed that the Nagaon burn unit in the civil hospital also has been discontinued as Nagaon Medical College and Hospital has also come up in the meanwhile. Since full-fledged hospitals are running at Dhubri and Nagaon, the services of the appellants were discontinued on the ostensible ground of their appointment on contractual basis having been made by the health society and not by the government, and that the entire mechanism under which treatment to burn victims were given have undergone a paradigm shift with the opening of 2 new independent medical colleges and hospitals at Dhubri and Nagaon, at Nagaon and Dhubri. The Learned Counsel for the appellant has submitted that all that they required was to consider their service tenure, their tenure during which they had imparted their services. Under the MOU referred to above, it was clearly stated that on successful completion of the project, the activities, namely the opening of burn units, will become part of a regular scheme, and its coverage in terms of states and institutions will be subsequently extended. The state government, in the aforenoted undertaking, agreed that it shall take over the responsibility for maintaining the burns department after the end of the 11th five-year plan, that is 31/3/2012, and along with it shall also take over the liability of the staff recruited on contractual basis at the end of the 11th five-year plan. The state government promised to take steps in advance to engage manpower on permanent basis for running the burns department. The state, therefore, as declared in the MOU, would be under an obligation to create regular posts against sanctioned contractual positions, so that by the end of 11th five-year plan, necessary posts would exist for a smooth continuation of burn care services. The further promise of the state was that the officials to be engaged on contract basis initially would be engaged only if they are found eligible as per the guidelines laid down. With this declaration in the MOU, the appellants expected that their services too would be regularized, or at least be made to appear in the recruitment process for filling up those posts for running the burn centers in the two hospitals which have come up over a period of time. Their claims have been repudiated only on the ground that their initial appointment was by the State Health Society, which itself is no longer in existence, and that in place of those burn units in the civil hospitals, independent medical college and hospitals have been set up at Nagaon and Dhubri, requiring the earlier civil hospitals at the two places to be dismantled for all practical purposes. The question is whether the state can come out of this promise and not allow an avenue for the appellants to apply for different contractual posts which otherwise would have been regularized by now and sanctioned too. At this stage of hearing, we thought it fit to request the Learned Advocate General to look into the matter so that the trained contractual employees in the erstwhile burn care units could get an avenue for coming in the service of the state in the two hospitals referred to above. which would be beneficial for the hospital administration as also for the appellants. The learned advocate general submits that he shall look into the matter and get back to this court on the next day. Re-notify on 24th of September.
Deeply obliged.
Item 11.
Okay, yes.
This is the appeal preferred by the state in the finance department against the learned single judge's order. The very brief facts, His Lordship, that the read petitioners are retired BDOs in the Panchayat and Rural Development Department. And there was a revision of pay in 2017. There was enhancement of their basic pay, and that amount has to be given to a fitment table.
Yeah.
2 fitment tables were initially given.
In the sense that the
How the pay scale will be correlated with the enhancement.
scale and the table.
Yes. So there was some doubt raised by the Accountant General Office. A letter was given to the Finance Department, and Finance Department issued a letter to them whereby they have said that the appropriate fitment table will be 18.5. Okay, number page page 117. So when that letter was issued, sorry, I'm sorry, page 159. May I just read it, Lordship?
Yes.
With reference to your letter above, I am directed to inform you that for fixation of pay of Block Development Officer BDO on 1/4/2016, the procedure shown as case A1A at Appendix 6 at page 350 of ROP Rules 2007 may be followed at Annexure 1. The amended table 1.18 as per notification dated 9/3/2019 is enclosed below as Annexure 2. So this was sent to the AG office for calculation and giving proper appropriate benefit. The table is at page 160. This is the amended table. This was put to challenge by a very small group of BDOs. According to them, if this particular table is followed, 1.18, then their actual pay will come down after calculation. In our affidavit, we have said it will increase by 11,000. That Lordship will kindly find in our affidavit. Very clearly, we have stated, finance affidavit, Lordship will find it 138. We have done the calculation also. It will become 1 lakh. They will get 79,000 instead of 68,000. So I'm not going to the nitty-gritties here now today. Then the learned single judge came to a conclusion because there are 2 views. One view, according to the writ petitioners, that their ultimate benefit will come down than the actual amount, which is 62.770. Whereas our case yours, it will become from 62, it will become 79,000. And therefore, the learned single judge passed a direction to the finance department by setting aside that communication which we have issued to Accountant General's office. That was set aside. And there was a further direction that we have to revisit the fitment table. So I have 2 basic grounds of challenge here, without going into the other nitty-gritties. That if a particular ROP, revision of pay rules, is to be amended or tinkered with, it has to be challenged and it has to come before a division bench. It is a rule under 309. That is number 1. The learned single judge, in my humble submission, according to our High Court rules, does not have that jurisdiction. And number 2, this is a totally an expert body's exercise. So if somebody is aggrieved, then they should challenge the particular fitment table as well as the ROP. There are anomalies committees, lot of procedures are there. All other departments, including their colleagues, have no grievance. What they have done, they have annexed.
One thing before you complete. Now, this is only a a remittance of the matter to the finance department to revisit.
Revisit.
Now, if we qualify the order
Yes.
saying that any opinion given by the learned single judge shall not be taken into I mean, the finance department shall not be under an obligation to show the same line of reasoning and shall decide afresh, revisit it and pass necessary orders.
That is the easiest way to do it. Even we can do it, Lordship.
We look for the easier
But
way.
the thing is that while they have challenged this particular communication of finance department to AG office, they submitted a representation to us annexing their own fitment table.
No, that is.
That was given and that was rejected by a speaking order.
Multiplier mode is something more than what is admissible.
Exactly, Lordship.
You perhaps there, it has to be applied, the multiplier mode of one.
Now, what will be the result? If we can look into it, finance department on its own cannot do it because it has to given place before the same pay revision committee. So the whole exercise has to be redone. Pay commissioner time will.
But and if it is found that it is not good.
Much 79,000 to 71. It will either not please.
Now, Mr. Chaudhary, you are appearing for the.
I'm appearing for the.
The finance department take a fall on this.
No,
And they revisit.
No, there is a problem. Now, nobody has assumed the role of expert in this case, madam. It is a department who has given us some benefit. We want that only. We are not asking for anything else.
We are on a different issue altogether. Mr.
Yes,
Chow.
yes.
The question put to you is this. Now, this order of remittance.
Yes.
For revisiting the entire schedule.
Yes.
And the methodology for computing the grade pay and the enhanced pay. This can be done only by the pay revision committee.
No, my lord, the pay revision committee has done it in exercise of power under 309 proviso. This has been made. We want implementation of that order. Nobody is asking anybody to assume the role.
You are asking.
No, my lord, kindly see. That's the whole difficulty. Please, order to give us page. 309 order to. Yes, my lord will kindly come to page 90. This is the order we want implementation of this order, nothing else. It is what Ladis Single Judge has directed, my lord.
Which page?
Page 90, my lord.
Yes.
In exercise of the power conferred by proviso to Article 309 of the Constitution of India, Governor of Assam is pleased to order that following amendments shall be made in schedule to the Assam Services ROP Rule 2017, published in extraordinary issue of the Assam Gazette dated so and so. In the pay schedule under the head Panchayat and Rural Development Department, below the subhead Directorate of Panchayat, the following existing entries in column 4 and 5 at page 562 against the post of Block Development Officer shall be substituted as below. Existing pay scale, 8,000 pay band 3, 8,000 to 35,000, grade pay of 4,700. Now it should be, my lord, pay band 4, 30,000 to 1,10,000. Now, Lanet Single just says that corresponding fitment formula you sent it to AG, that's all.
No, it doesn't.
No, my lord, there's one problem here.
It doesn't stop at that, no?
Yes.
Why did you go to, if that was so, why did you go to the court?
No, my lord, what had happened, when they wanted to implement it, Office of the Advocate General wanted that there should be a corresponding fitment table.
Correct.
As far as grade pay band 4 is concerned, there is no corresponding fitment table. Now, my lord, no,
There has to be a fitment table, no?
yes. If a lordship would kindly have this book, my lord.
No, that is.
My lord, I'll just, from the ROP rules, I'd like to place two things, my lord. No, basically, the learned single judge has not assumed unto itself any function of the revision of pay rules or something, my lord. All that learned single judge directed is corresponding fitment table to provide to the advocate general. That's all, nothing more, nothing there more than that, my lord. Otherwise, my lord, this benefit is being denied to us.
Was it, why, this direction could have been given without remitting the matter, no? To revisit the entire scheme.
No, I don't think that's the entire thing, my lord.
Let's see.
Yes, my lord. The direction, the judgment starts at page 180, my lord. Lordship should kindly come to page 190. Please come to 201.
Come to paragraph 11. At
Yes,
page-
precisely, I'm on 11, my lord, yes.
Page 22.
Ah.
Just
201, yes. Under such circumstances, in view of the discussion made by this court is of the considered view that finance department will have to specifically lay down an appropriate fitment table enabling petitioner to receive the benefit of higher revised pay scale which have been conferred by the department as per notification dated 23/2/21. Accordingly, this court is of the view that this issue needs to be revisited by the department to the extent of deciding appropriate treatment table, which will enable respondents to be conferred with the benefit as conferred.
Agree. So now come to the communication dated 2/3/2023.
Yes. Page 90, my lord. 2/3. 2/3.
Or 23.
Yes.
159.
Now, why this question arose, my lord?
Just a minute.
There is no fitment table corresponding to pay band 4. That is why this problem arose. In respect to other posts, Government of Assam has done for a post which is slightly above us, my lord, where there is appears there is a consensus.
Now let's see
Yes.
that communication of the finance department.
This is page 90, my lord. In the pay schedule,
Where is the, that's.
Is 159.
Page?
159.
Yes, no, my lord, this pertains to pay band 3. That's why I was trying to refer to the book, my lord. I'll explain the position, my lord. How this problem can be addressed.
Yeah, 1 second.
Yes. Affidavit court posted by
The fitment table is at annexure 2, page 160. Is this the fitment table?
Yes, Lordship. The amended one.
Where do we see state of pay after? Now, where do we get the pay band 4 table?
No, it's not there. Pay band 4, there is no table. That's the problem.
No, but what is it written here? Anywhere, any mention? This is not an extra.
I'll place from the book, my lord. Yes. Yes. My lord will kindly come to page 56, my lord, of this book.
Paging would be the same.
Same. I think so, same.
Now, these are photocopy.
Oh. My lord will kindly come to appendix 1, table 1.18.
Mr. Chaudhary, do one thing. Tomorrow, we will hear you tomorrow. Now, his arguments are twofold.
Yes.
Number one, that if the fitment table has been given and you say that there is none.
Corresponding to pay band 4, there is none.
So,
but in case of a post,
is prepared by whom?
By the competent authority.
Now, in this case, who would be the competent authority?
Finance department.
Pay commission, Lordship.
Pay commission. So, what, my lord, there is a particular department, pay research unit, na? Finance PS.
Therefore, he has first questioned the very idea of remittance.
No, my lord, here it is not a case where the learned single judge has usurped the power of somebody and given a direction.
The ROP which grants you some benefit monetary,
yes.
that cannot be taken away.
Yes.
It's only, that cannot be taken away.
Yes.
It's only once it is notified, accepted, it can be rejected by the government.
Yes.
But once it is accepted by the government, you can't be.
They're bound to give it. Yes.
But the question is that it has to be paid in accordance with, it should correspond to the fitment table.
Correct.
That's easier calculating.
Yes.
So they say that fitment table, the multiplying factor, what should apply to you is 1.18.
Yes.
You clamor that you have got less because you assume it that the multiplying factor would be 3.36.
No, my lord, that is their apprehension. Actually, it will be not. I wanted to show that arithmetic, my lord.
No, but why? If they
No,
say.
just to show, my lord, just to
They say that
demonstrate that the basis on premise on which government is proceeding is not correct.
No, suppose the state says that the you shall be paid in accordance with the fitment table. And since there is no fitment table for pay band 4, it would apply the principle of marking. I mean, the calculation would be with the multiplying factor of 1.18. You don't have any objection. But can you claim that the fitment table, the multiplying factor should be 3.16? That's your.
No, that is not our case. That it should, it is they say, my lord. Now, why they say so, there is one, I mean,
They give an affidavit that it shall be done in accordance with the fitment
my lord,
table.
there is, if your lordship.
Where are the fitment tables?
Yes, that's what I'm showing, page, table 1.8.
Yeah, you give us a short.
My lord, in that case, my lord, what I'll do.
No, no, this table, it has been provided to somebody.
My lord, this is part of appendix 1, table 1.18.
We need to have the we need to have the page number, Mr. Chaudhary.
Page 5.6. Oh, acha. Can I find out from the, no, no, see.
It can be amended. Amended.
Mr. Chaudhary, you
Yes.
just formulate your argument.
Yes.
Tell us. Three issues they
My lord,
have been vexing our mind.
our case.
If this were so, if this is by virtue of the provision contained in proviso to 309, can a single judge hear this?
No, there was no challenge to any notification, my lord. All that way one was implementation of an order of the authority.
That's all right. So
Yes.
they say that.
No, my lord, there is no question of single judge division bench in this matter. Yes. If an ideally a rule is challenged, a notification is challenged, challenge lies to my lord division bench. There is no dispute on that.
So-
But we are not challenging any government notification.
If that is so.
All that we are saying is
No,
please implement it.
But do you say that you accept the multiplying factor of 1.18? Then they have no case. They will say, good. We do
No,
it.
multiplying factor of 1.18 as is provided here, my lord, it is in respect of pay when 3.
That we have followed. So
Yes.
Therefore,
My lord, the answer lies in, they have already found it out. They have applied that without there being any corresponding table. They have already done it in respect of some other officers who are just above 1 grade above us. We are saying, please do like that. Their finance department is not raising any objection. Kindly see, my lord. Why they arrived at the 3.30? The reason is they have skipped this. In between, my lord, our pay were revised. Actually, in the recital, it should have been dropped 22,000 to 87,000, 230,000 to 1,10,000. That is why this figure of my lord, 3 point some has come off. It will be only 1 point something, my lord. minus 8700 না? 10,000 10,000
So you don't agree with this table number 1.18?
We agree, my lord. We cannot have any quarrel with this, but this is
for PB3.
Yes. Page number ki mana
how can they say that?
Page
Look,
number
look at
four,
this, you have gone further
Yes.
from 87,000 to some other figure. What is that figure?
What they have done, Milord,
What is that figure?
that should have been, Milord, the middle one, 22,000 to 87,000. In between, Milord, we are on this revised pay scale. That's why this figure of 3 is coming out. That's what I wanted to show, Milord. Now, please come to page 280, Milord.
No, this paging, you give us a short.
Or better we give this book, Milord.
Not only the book the High Court can provide us, but if you give.
I'll come up with a note, Milord.
Come up with a note with the corresponding paragraph.
Yes.
No.
But slightly technical, Milord. It's not.
Doesn't matter. It is not some aero science.
Yes,
We can-
yes.
By raking some part of our brain, we can handle it even though.
Certainly it's not rocket science.
The table of, I mean, if they have missed out on that table, then we consider.
Yes. And I will certainly demonstrate, my lord, all that is required is to.
But then it would be applied across the board.
Across the board.
So can you make a comparison with
Yes.
the table which was used for calculating the height with respect to a stage higher than you?
Yes.
No, you can't.
No, my lord, they have already done it. That is under consideration. We'll rely on that. For the post of my lord, Deputy CEO, which is above the post of BDO.
But in that case, this page 159 of the brief.
Yes, my lord.
कहाँ से लिखा हुआ है 1.18 में? 1.18, where do we get it from? Annexure 1 is this. So how do we say annexure 1? This amended table 1.1. They say that they have another fitment table. Where is that fitment table that you are suggesting? 3.38. This is not, again, we committed a mistake. This 1.18 is not the multiplying factor.
No.
It's a table number.
Table.
I thought
We have to arrive at that multiple number by taking some Milord arithmetic.
Where is that table?
That I'll find out. I'll come up with an example in my note, Milord.
Okay. Otherwise it is difficult to sustain your.
No, absolutely. Lordship is correct, my lord. That multiplying factor can be arrived at by doing little bit of arithmetic, which will do and bring it out in the form of an illustration, my lord.
Now, who has to the PRU has to provide the fitment table?
No, actually, it is none of our business. But having gone through this, my lord, we have realized this is how it works out. One can figure it out, my lord. There's no difficulty. So that's why I propose to, my lord, come up with an
Who will do it?
example. No, we'll do it. And eventually your lordships will say yes or no, but we can only give it.
That was the source of all
Now,
problems.
if Mr. Saike would agree that let the finance department revisit it without raising any objection, pass an
No,
order,
Lordship.
we'll see it afresh.
Paragraph 17, we have very clearly whatever argument is coming from the other side, everything is dealt with.
Paragraph 17 at which page?
147.
I think in that case, there will be another round of litigation. Better lordship take a call, my lord. We'll come up with that note, my lord. Otherwise, my lord, this was not a case in my humble submission where states would have come up on appeal. The answer lies in providing a fitment table, nothing else. It was the duty of the government to provide the fitment table before prescribing, my lord, that higher pay scale and higher grade pay. And my lord, the same accountant general, in case of deputy CEO, they themselves have prepared it, proposed table. But in our case, they are insisting that I should apply and get it from the government. উদাহরণটা করে দিন অঙ্ক খালি না হবার নেক্সট ডে ফর্মটা আপনাকে করতে 1.1 একটু হবই নয় এটি পেবেন শেষ আর নেই
We have prepared the chart also, page 150.
यानी यहाँ पे पेज तो लिखा है they say that PRU, pay research unit, they cannot provide a fitment table. That it has to come from the
Pay commission, pay revision commission.
that's their case. There's a clear statement in page 148.
I've seen it, my lord. And my lord, since they are considering they are the level of the deputy CEO, let us see. And my lord, let the matter come next week, my lord. I'll come to yes. Not
Plus,
tomorrow,
you have to
tomorrow.
tell us now. Clarity is required with respect to two. Fitment table, they don't provide. They don't provide fitment table. Where from did you bring this multiplying factor of 3.36 or something? Did you get that?
No, my lord.
That's very interesting, but where did you get that?
Yes,
That
I can
with
show, my
respect-
lord. I can show.
No, do it on the next.
Okay,
date.
okay, yes,
On the next date, we are only pointing out what is not understandable to us.
yes.
Now, if the ROP rules provide for a particular fitment table for a particular class of officers with particular grade pay, even if something is amiss, the matter has to go back to ROP. I mean,
There is an anomaly committee for that. That exercise is also done. Anomaly committee. That is a part of the exercise.
Can the courts enter into it unless prima facie patently illegal?
No, my lord, problem is we are all
Suppose-
retired employees.
Suppose we allow, that we understand that, it concerns not legalism or legal rhetorics. If you're entitled to it, the state has accepted.
Should
you
get
must
it, yes.
Now, the question is this, now, even if, according to the learned single judge, if the order is implemented, the finance department says something, under which authority?
No, my lord, I don't think a single judge's order can be construed as, my lord, overlapping with the functioning of the competent
No, we
authority.
don't say that.
Yes.
We are not commenting on it on this level, not at all. Suppose we agree that there were two fitment tables being referred to by the contesting parties. They
Yes.
just thought that the best way out is to send it to the finance department. Now, suppose we permit that. Sitting in the judicial side, we say that we don't want to interfere. Let the finance department even say that we can't do anything in the matter. Therefore, the remand is all right. Now, but I'm asking this question from you, what would the finance department do in this
Yes.
matter?
The answer is,
PRU is not the authority.
answer is rule 12 of the rules, my lord.
What does it say?
If any question arises relating to the interpretation of this rule, it shall be referred to the government of Assam in the finance PRU department, whose decision thereon shall be final.
They are finding the procedure a little bit.
No, lordship is technically correct. I am not on that. Here, my lord, we are faced with a peculiar predicament where a corresponding fitment table for payment for is not
The
there.
whole difficulty has arisen because of your projection, your means,
Yes.
appellant's projection.
Yes.
That the multiplier method of 3.36 has to be applied. They have only applied one.
That is not our ground, that is their ground, which we are saying is not correct. This is not, that is
No,
not
no,
arrived at
that's your
correctly.
ground.
Huh?
That's your ground. That is what is there in the judgment.
Appellant's precedent is no, we are not the appellant, the state is the
No,
appellant.
no. That was the case before this learned single. We understand the state is the appellant.
No, my lord, we never say, on the contrary, we say it is within the permissible limit. Because why that jump has taken place, my lord?
They admit that there is no fitment table.
Yes.
Mr. Sakya, you admit that there is no fitment table.
There is
for payment for.
fitment table. It is the amended fitment table which was given to accountant general,
No, no.
and that letter has been challenged.
That letter has been
Yes,
challenged.
initially there was a fitment table. There has to be some amendment. So amendment was done by the pay research, not
That fitment table, does it take note of the height in the-
everything.
height
In fact, initially there was 37 points. When the amendment, it came up to 41
The
points.
fitment table is comparable to the old existing pay.
No,
Yes.
to the revised pay also. That is what in paragraph 19 we have stated in the last part. We have very
Anyway,
clearly said.
We will have a look at the matter. Remittance, still we are not very satisfied about the learned single judge having remitted the matter.
But while remitting,
Assuming but not admitting the contents of Rule 12 that you read out to us. That's with respect to interpretation of rules. This is no interpretation of rules.
The end of the day, Milord, the purport of the rule is in case of any, I mean,
Any difficulty with respect to
incongruity.
selection of the fitment table.
Yes.
Now, it's only the BDOs that are facing the brunt.
a small group, other colleagues all are happily accepting.
No, my lord, the difficult part is the person who have joined subsequently after this, they are getting the benefit. We are the ones who retired and not getting. Even the BDOs, current BDOs, they are getting.
Simplify your argument. I mean,
I'll do that, my lord.
considering that we are generalists and not.
No, even I'm more generalist, my lord. I find very technical these things. That naturally, my lord. Next week, next Monday, let the matter be called, my lord. We'll come up with that note.
Mr. Advocate General, you also tell us how the fitment table and how it is calculated.
Tough exercise. I'll do that, Lordship.
And we don't come across this type of cases often, my lord, sometimes.
And how the finance department to say that nothing can be done, this is the one.
No, that exercise was already done. That we cannot do because even finance department, because when a pay research committee.
This would be a learning experience.
Lordship, we'll do.
First.
Lordship, we'll do that.
Let us see. Because these matters keep coming to court.
Yes.
We don't entertain such petitions for the.
That is a settled law, Lordship.
Well, there are two ways
That
of
is a
looking at
settled
it.
law.
Either
That honorable court will not interfere anything regarding this highly expert committee's exercise, sending it back. So if anything is to be done, it has to be done by the next pay commission. That is the normal procedure, and it was done in 2016. So now next pay commission is due very soon. And for this kind of anomalies, there is a time limit, and within that time limit, within 1 or 2 years, the anomaly committee sits. That is a part of the pay revision commission's exercise. So anomaly committees takes over everything whenever this kind of objection or complaints come. Anyway, Lordship, next date I will make my submission.
And who prepares the fitment table? It's done by.
It is there. It is highly technical, and it is nothing to do with the finance department. Several experts from various fields are joined together to form that committee, that commission.
Please.
Yes,
give a
Lord.
flow chart of everything.
I'll put it, Lordship.
You also, Mr.
Only 3%.
So, Lordship,
is
maybe
to be
please
added,
admit the
nothing
appeal,
else.
Lordship. I'm not praying for any stay order. Admit.
This appeal is admitted for hearing.
Deeply obliged, Lordship.
The learned AG, as also Mr. K.N. Chaudhary, learned senior advocate appearing for the respondents, shall furnish on the next date a short notes of argument.
Yes.
And if possible, a flow chart with respect to the procedure.
Lordship.
For suggesting a fitment table in case there is no fitment table available for a particular payback.
Particular.
Could it be after vacation, Lordship?
List this for hearing on, list this appeal for hearing on. First week of November.
Lordship. Highly obliged, Lordship.
6th of November.
But normally we don't admit appeals. We decide it. So on that day, please let us know what is there.
No, certainly.
Don't want to leave the trouble for the for the coming generation, new generation. We have faced it in Patna.
Okay.
Earlier in late 70s, even late 80s and early 90s, any contentious this appeal is admitted for you. And
Something,
it goes to
And
the back.
in due course,
Ah.
it will come in due
In
course.
due course, it goes to the back burner.
something like in Supreme Court, leave granted.
But leave granted, still you have the option of coming. But admitted list for hearing in usual course, that will come only after 5 years.
Highly obliged, Lord.
Item 26 and 27.
May I please your lordship? Lordship, in
Yes.
this case, item 26, we are for the respondent, and in item 27, we are for appellant. Today, lordship, we have been engaged, Mr. T.J. Mahanta has been engaged in this case today, lordship.
Today he has been engaged for item number 27.
26 for respondent and 27 for appellant, lordship. So, lordship, I pray that.
Council was appeared. All right. When do you want? When do you want?
After 2 weeks, lordship.
As prayed for, on behalf of the party, re-notify both the appeals on after vacation.
3010. 3010. Item 28.
Yes.
May I please, Lord? Lord, here the order of the Central Administrative Tribunal has been put to challenge. My lord, the respondent herein, my lord, he was initially, my lord, serving as a goods guards, and my lord, thereafter an option was invited from the department.
Give us 1 minute.
My lord.
ये बीच का कोई पीरियड के लिए करेंगे. He was asking for something in between. No, that's true. But then he ultimately got that. He finally was a section controller or something. He got it. But in the meantime, what he lost out, he wants to be compensated. Let's see what thinking. Let's see that.
Now your services were calculated from 27/3/2009. It should have been, according to you, it should have been calculated from 18/12/2008. Is that correct?
No, my lord, that was correct.
No.
Yes.
The respondent. Sorry, you're the Union of India. Is it correct, Mister?
That was done. Corrected.
But in this case, particular. No. We are asking you for one thing. We'll get back to you. Yes. Now, your services were calculated for the purposes of promotion. Yes. From 27/3/2009. Yes. You claimed before the tribunal that it should be calculated from 18/12/2008. Yes. I think that's your case, no? Yes. Because that would have included the period of probation or for that matter, period of training.
My lord, probably there is 2 cases.
I have asked you for one.
Yes.
One question entails only one answer.
Yes.
Yes or no?
2008.
Then we will get back to you, please.
No, This was the, it should have been from 47/3/2009, and it was treated as 18 judges to have. It's for a totally different issue. I thought it was promotional or something. Oof. Now, what is there to object in this?
My lord, there were, my lord, if my lord take page 42, the prayer made before the tribunal, page 42.
Forget about the prayer now. What has been decided that upsets you because financially it affects the status.
My lord, the first prayer which has been granted, second prayer, my lord, regarding the date of promotion, that we have already corrected.
So the order only, the tribunal's order is only with respect to the recovery. And they say you can't. Because it was fixed. And I also asked him, he nodded. That was a wrong recording by the tribunal.
My lord.
In fact, you fixed his pay, the railway administration fixed his pay, considering that the pay was wrongly fixed from 2008. It should have been fixed from 2009. Asked, he just said the opposite of what is the correct fact. But nonetheless, after all this was done, you started recovering without issuing any show cause notice. And that was beyond 7 years, so Rafiq Masih gets into operation.
My lord. No, my lord, that is not the issue. If my lord will take, my lord, paragraph 9, 8 and 9.
Forget about his petition. Look at the order, page 100, page 102.
Page 27 is the, my lord,
Yeah.
and 28.
Page 25, it starts from, my lord.
We are not concerned with that. The tribunal's order is under challenge.
Yes.
Now, please go to page 102. That has been corrected.
That has been corrected.
102.
And that is a more different epidemic. Epidemic.
Mr. Union of India.
My lord.
Just come to page 102 and 103 and tell us where has the tribunal gone wrong. We would say even more strongly.
My lord, 102 is not the order which is under challenge, my lord.
What is the order then under?
Order
This
under
is the last
challenge is
three
at
orders
page 24, my lord. Page 20. Page 19.
It begins from page 19.
Begins from page 19, my lord. Page 25 is the operative part, my lord.
We were only at the recovery part. Let us see now.
Yes. My lord, it is on
The practice of the registry is that the impugned judgment or order is always placed in the last, so that it is not numbered. The impugned judgment is never numbered as annexure, so it is always placed at the last. But no, I don't know. Let's see.
paragraph 7.
1 second.
My lord.
Then the guy- एक मिनट इसको खोलो, एक मिनट। Control. उस समय हम पर स्पेसिफिक नहीं थे, ये being the senior was not made. Yeah, that. Nothing. He became section controller on 27/10/2000. So before that, he was senior goods guard or a goods guard. So, yes. Still right. Ah, such a petty issue which you have challenged. And just the,
The way it has been written, it appears that it's a dispute about promotion, it's a dispute about payment, it's a dispute about recovery, but the dispute is nothing. It's only a presumption, and the presumption is based on certain facts which are not in doubt. Right? So this respondent was made section controller
My lord.
on which date?
My lord,
27/10/2016.
yes. Yes.
Right. I asked you a wrong question, therefore the wrong answer.
That is what, my lord, I tried.
Sorry, I thought that was the impugn order. Please speak. I withdraw whatever I have said.
My lord.
So he became a section controller on 27/10/2016.
Yes, my lord.
He couldn't have become a section controller unless he were in the feeder cadre of goods office, goods guard or senior goods guard. Now, senior goods guard is a post which is filled up from amongst goods guard
My lord.
on the basis of seniority, not merit seniority, on the
Yes.
basis of seniority. So 3 persons below him were juniors and they were appointed as senior goods guard.
My lord.
That his name was deleted only on the ground that he had appeared. He had opted for selection controller,
Selection post, yes.
section controller,
My lord.
selection post,
My
and
lord.
therefore he cannot be promoted. That presumption was wrong of the railway administration. So prior to that, he would be entitled to be promoted or treated as senior goods guard,
My lord.
and all payments and other things would have to be given recomputed. Where is the difficulty?
My
Tell
lord,
us.
my lord, here, my lord, he was selected as senior good guard on 1/10/2015. My lord, 110, page 54. And
That's right.
yes.
That is not a fictitious date. That's
Yes.
not a
And
illusory
his-
date.
his
That's the
promo-
date from which you gave promotion. He's
My
not
lord.
even asking for promotion from other days.
And his promotion to goods guard, my lord, he was entitled on 18/11/2015. If my lord takes page
No.
62.
Whatever is the date. Now tell us whether these 3 persons, kya naam hai? Pranav Kumar Dev, Rajiv Koch, and Rajan Chandra Das and Jayanta Kalita.
No.
Were they seniors to him or junior to him?
No, they were juniors, my lord.
So therefore, even if he were entitled for being promoted to the post of senior goods guard, sometimes prior, he is not even asking
My
for
lord,
it.
since he has exercised this option, my lord, an
No.
option was called for.
Suppose you're an advocate.
My lord,
After completion of 7 years, you apply for
that
judicial
was
service.
not a normal
Just a
course
minute, you
of
apply for
promotion.
judicial service.
My lord.
The results are yet to come. Now, can the government say that, well, you will not be able to be made APP because before 7 years you have opted for another selection process? Can the government say that?
Well, because there are 2 modes, my lord. One is, my lord, appearing in a departmental exam to a selection post, my lord.
That's again a different issue which
Yeah.
you're raising.
That was that is what, on this ground only, my lord, we are saying he is not
Where
entitled
is
to
that
both.
discussion?
My lord, page 53. This was the letter by which the option was called for. Page 53.
Let you pay, we will hear you.
My lord.
53. Yes.
My lord, may I furnish the clear copy? Perhaps I think, my lord, the records is not clear.
What is it?
My lord, this is a letter by which the options were called for from the following categories, my lord. That is goods guards and senior good guards. This is not a regular promotion, my lord. This was an option called to appear in a department.
Make a difference. Which rule, which service jurisprudence tells you this?
Because, my lord, once an option is exercised,
So?
It is after that, my lord, he was promoted to the post of goods guards on 18/11/25.
He was never promoted to the post of section controller prior to that date.
Yes.
So otherwise also you would have become, suppose you had not selected him, then merely because he had applied for it, does it mean that his right extinguishes? I don't think so. I mean, I can't think of any logic.
My lord. No, this is under rule, my lord.
Unless it were under the rules.
Page 76, my lord, rule
How many
1316.
pages you will make us read? No, page 76.
Page
What is the rule?
76. No, this is the Indian Railway Establishment Code. My lord, Rule 1316, my lord, deals with such a situation, my lord. A point has been raised as to how the pay of a railway servant who happens to be promoted to two different posts carrying higher responsibilities on the same date should be regulated.
It is on the, is it on the same day?
It is not on the same date, my
Then-
lord. This is not on the same
Is
date.
it applicable? Where is that provision that you're reading?
Even presuming, my lord, on the
Where is that provision that you're reading from establishment code?
my lord, subsequently it is there, my lord.
Which page, which paragraph, which line?
The page 76, my lord. Page 76, the subsequent parameter. He should be deemed to have been.
Who should be deemed? We are not getting the line.
My lord, Railway Board's order, my lord, it starts from that. In the middle, my lord.
Railway board's order.
Railway
Yes.
Board's order. A point has
Read,
been
read. A point has been raised.
as to how pay of a railway servant who happens to be promoted to two different posts carrying higher responsibilities on the same date should be regulated after introduction of Rule 1316 with effect from April 1, 1961. He should be deemed to have been promoted first to the lower post and pay fixed under Rule 1316, provided it is certified that he would have held this post.
How does it apply to him? One, the section controller is a
Because
higher
he was
post
not
than senior.
promoted to senior goods, my lord, prior to his exercising of the option,
That is what you claimed when he got it.
my lord. My lord, that was our my lord, plea before the tribunal also.
Take it, take it.
My lord.
Any further argument will lead to admission of this appeal.
I'll leave it on you.
Above that, my lord, the rule covers me. Para 11, benefit of pay admissible. Above that. For stepping up of the pay. Roman 2.
Union of India.
Roman 1, they were promoted by seniority, senior goods guard. So I should be protected by at least by personal pay. And thereafter, my lord,
We are affirming the order passed by the tribunal.
My-
You want anything more? We admit this. appeal.
oblige. No, my.
Sit down. Yes, no. We have heard Sri H. Gupta, learned advocate for the appellants, bracket my Union of India and three others, and Mr. S. Nath. S. Nath,
Yes, my.
Mr. S. Nath for the respondent. The order of the Central Administrative Tribunal dated so-and-so, dated 1st of August 2023, passed in OA number 204 of 2017, is under challenge. The records reveal that the respondent while working as goods guard in the railway had opted for a selection post by the name of section controller, for which post the feeder cadre comprises the posts of goods guard and senior goods guard. Next. For being selected to the higher post of section controller, comma, a goods guard or a senior goods guard must have completed 2 years of minimum service in the immediate lower grade of notified post, comma, should not be over 48 years, and must be qualified in train passing. After being selected, a section controller has to undergo a training for a total period of 12 months in the yard and control office before being posted as a section superintendent. Okay? What is that? Which superintendent? Section superintendent. What is that post?
Section controller, my lord.
Section controller. Section controller. If the candidate in question does not come out successfully in the training, his name would stand deleted from the post of section superintendent. Section control. From the post of section controller, section control. There is no cavil on the factual position that the respondent was appointed as section controller on 27/10/2016. Thus, before 27/10/2016, he would have been serving the railways on the post of goods guard, notwithstanding the fact that while serving as goods guard, he had opted for being selected for the higher post of section controller. The records further reveal that the post of senior goods guard is a non-selection post, which is to be filled up on the basis of seniority. The respondent was the senior most goods guard, but was not admitted as senior goods guard for the only reason that he had opted for being considered for selection to the post of section controller, which ultimately he did. By passing him, three goods guards who were junior to him, namely Pranav Kumar Dev, Rajiv Koch, and Rajan Chandra Das. Pranav Kumar Dev, 4. Pranav Kumar Dev, Rajiv Koch, Rajan Chandra Das, and Jayanta Kumar Kalita. Kalika, prior to that? Were placed high in the merit list. Were placed high in the seniority list. On the day when the respondent was promoted to the post of section controller, he was the senior most goods guard, and therefore he was only entitled to be posted as senior goods guard. Senior goods guard, which entailed with it higher pay and other emoluments beyond what was admissible to a goods guard. This aspect was overlooked for the rectification of which the respondent had approached the tribunal. The tribunal found
that bypassing the name of the respondent in the seniority list would be only bypassing only on the ground that he had opted for being considered for selection to a higher post was not tenable. Precisely for this reason, the tribunal directed that the respondent be given promotion to the post of senior goods guard from 18/11/2015, the date when his juniors were promoted to that post, till his actual selection as section controller on 27/10/2016. The tribunal further directed to recompute the salary of the respondent and make him available the arrears within a stipulated period of time. This has been challenged by the appellant. This judgment has been challenged by the appellant on the ground that according to the rules in the railway, in the Indian Railways, कौन सा पेज निकाला था वो? According to the rules in the railway, the pay of a railway servant who happens to be promoted to two different posts carrying high responsibilities on the same day is to be governed is to be considered, no, is to be computed, is to be regulated in the following manner. First off, he should be deemed to have been promoted first to the lower post and pay fixed under Rule 1316 bracket FR 22C bracket close R2, which post he should have held for not less than 22 days, but for his promotion to the highest post. First off, if the person concerned should subsequently be promoted to higher post and pay fixed under Rule 1316 bracket FR is fundamental rules 22C bracket close with reference to the pay arrived at by the aforementioned computation process. Though this issue was not raised before the tribunal, but on reading of the Railway Board's orders with respect to fixation of pay of a railway servant who gets promoted to two different posts carrying higher responsibilities, it appears that the above noted FR would not be applicable to the respondent. The senior goods guard is not a selection post, and a person is appointed on such post from amongst the goods guard by reckoning his seniority. Stop. Admittedly, the respondent was senior most goods guard prior to his being finally selected as section controller. Stop. Precisely for this reason, the tribunal directed for rectification of the records of the respondent, holding that he would be entitled to the pay and emoluments of a senior goods guard from the date his juniors were promoted to that post until he became the section controller. We find no anomaly in the order of the tribunal for sustaining the objection of the appellant. The appeal is dismissed.
All right.
Item 29.
My lord, the matter relates to granting of temporary status. Similar order lordship has already passed, my lord.
Yes, my lord.
Indeed. No, the order. And we have also prepared a small list of dates, my lord.
You give it to us.
Yes.
Exactly similar.
Similar.
Oh, my brother had written that. Yes,
Yes, my lord.
allowed in terms. They're the next.
Deeply allowed.
Deeply.
Give your appearance slip.
My pleasure.
Item number 30.
Short need.
May it please your lordship. In this case, I have challenged the validity of notification dated lordship, that is annexure 1. Passed by the BTC lordship, page 20, annexure 1.
You appear for BTC.
Lordship, Mr. Nayak representing BTCs on legs in a different court. Lordship may take up the matter after some time.
Oh, after some time is not possible. A prayer for Passover has been made on behalf of the respondent slash BTC, which does not appear to be possible considering the board. Let this matter come up for consideration under the same heading on give a date after 1 week. Or after Dasara was it.
Lordship.
Lordship.
1710. Item 31.
Wait, please, your lordship. Lordship, in this matter, lordship, we are appearing for the interveners. Lordship, as per order dated 7/2/2025. Lordship, our
Order dated?
impeachment was allowed, lordships.
Order dated?
Order dated 7/2/2025, my lord. Over the last paragraph, lordship. But in spite of this, my lord, our name did not appear in the causes, lordship.
Just a minute. क्या कहते हैं उसको कार्बी हम लोग You were allowed to intervene, no?
Lord,
Then what
yeah.
happened?
My lord, the name of the interveners were to be reflected in the causes. Well, somehow it was not reflected
By order dated.
by order.
Have you filed any application?
My lord, this application was allowed. Being an
That's all
intervener.
right. So who are these interveners?
Well,
How
he-
do we get to know the names?
My lord, that application is before my
Has
lord.
there
That
been a change in the memo of parties?
no, my lord.
So no. If there is no change in the memo of parties,
Lord,
how do
there
we
is-
know who are you?
My lords, we as an applicant lordship has allowed
Or your-
before my lord that the IN and the.
Questioning that, Mr. Counsel,
Lord.
can't you understand?
Lord,
We
that
are
is two
about
things.
to direct
the registry to print your name in the cause list.
You know, that is IA number, Lordship, it is in reflected. Lordship. We had filed an IA, Lordship, that is 281.
Tell us your name.
H. Betala, Lordship. H. Betala.
H so and so. Vitala. All right, this is one prayer.
No.
Rest.
Lord, in this regard, Lordship, the KAC was required to file their response, Lordship. That is important, Lordship. That has to come on record. That they have not filed. And
Who appears for KAC? Why have you not filed? The Advocate General has already filed. Have you filed your detailed affidavit?
We have filed, Lordship.
What have you done to
No,
control this
Lordship,
rat
now,
hole mining?
basically, we have said certain things, but there is an inquiry going on by retired justice, one of the honorable justice of this honorable court. She has asked for the objections and opinions. Now, the extension has been given till 24th of October. So my prayer today would be that the matter will be taken up in the first week of November, Lordship. By that time, the inquiry is expected to be over.
This PIL aims at stopping rat hole mining in the entire northeast region. Now, it appears from the earlier orders passed by the bench that KAAC, पूरा लिखना, Karbi Anglong
Autonomous
had to file their response, but till date, no response has been filed. Mr. Chutia, learned advocate appearing for KAC, submits that the response of the council shall be filed by the next day. Mr. H. Vithala, learned advocate for the interveners, makes a complaint that despite the intervention petition filed by his clients having been allowed, his name does not figure in the cause list. The learned advocate general has submitted that though a detailed affidavit has been filed delineating the steps which are being taken for stopping rat hole mining in the area, but a commission of inquiry is looking into the matter, which has asked for objections from the stakeholders in the matter. He therefore prays that the matter may be listed. He therefore prays that for effective determination of the issues raised in this PIL, the matter may be listed in the month of November. Let this matter come up for consideration on your date in end of November.
24th November.
Henceforth, the name of Mr. Vithala must be printed in the cause list.
I'm grateful, Mullah.
For the intervention. Who appears for Dima Asao? You're sitting tight. You should have been the one who should have told us. The brother, my brother, detective, that you're hiding behind this balustrade.
Well, Dimasa has filed an affidavit, but says that I have no role to claim.
In fact, that is the correct position. They have no role to play.
You have filed the affidavit.
Yes, because it was under the Assam Mines and Minerals Development Corporation.
Rat hole mining, how many persons died in that incident?
9 persons died. That day, that one particular one incident.
After
it could not even be known who all were there.
My lord.
No, they were all found out, Lordship, number one, and that those mines were actually closed in 2012-13. For the first time, in a very clandestine way, they entered there. And that unfortunate tragedy happened.
And how
these are all closed wells.
There have been more because these contractors don't maintain the register.
No, there is these people.
I don't know that there were only 9.
Only 9, Lordship.
How do you know?
We found all the dead bodies and the families came also. There was no such any other complaint that anybody is missing thereafter.
Okay.
And clandestinely they have done after 12 years. See, these are all closed mining areas.
See,
some
Clandestine-
misadventure had
These
taken
workers-
place.
These miners would not have any interest except money by the end of the day.
Lordship.
So they were made to enter that rat hole by these, unscrupulous miners.
Unscrupulous, exactly, Lordship. And on the very first day they attempted it, that mishap had
You
taken.
have to find out their names, you have to prosecute them and make them liable for murder. Anyway, that's out of the scope of this.
No. It is, Lordship, it is very much well within the scope because we have, and this was in the very remote areas. Normal policing or normal inhabitants are also not there. Very deep area.
Okay.
Deeply obliged, Lordship.
Supplementary cause list for orders item 32.
Yeah. Yeah.
This IA.
After orders, you call the supplementary cases from next year. The last we are not there.
Yes, what is this?
This IA is for constitutional delay for 48 days.
Yes, what do you have to say?
The delay 48 days, that should not have been here because their controlling office is located in Guwahati.
We are condoning the delay application.
My lord, I was in the morning, my lord, item number 10, I failed to appear because the traffic jam. I couldn't, 1.5 hours I was stuck up.
But I asked you to come immediately after lunch.
I was here, my lord, I didn't want to interrupt.
No, I don't forget.
My lord, I'm sorry.
You didn't come. What had announcement? You were, what was the HSCL? You were appearing for which?
For the
FCI.
FCI. Any day, my lord, next week, any day.
Whichever date we have given, the same date would remain. Nobody appears. Chhod dena.
Yes.
All right, this we have condoned. The appeal shall be listed. Processed and listed. All right.
The next date,
Date they will.
2019.
29.
10. Item 33 and 34.
List. List. Where is that list? No.
What do you want?
My lord,
Mr. Bhujan.
hearing and disposal, my lord, at an early stage, my lord, because selection list is already prepared.
Fixed to 26/9.
My lord, what has happened, my lord? In the meantime, the selection has already, the third merit
Anything
list.
can be done. We'll turn the hands of the clock back. We can, provided you make out a case.
My lord.
Mr. Chaudhary is not very, he doesn't think that this statement of the bench is correct.
My lord.
We'll turn the hands of the clock back.
My lord.
I'll let it remain.
No, my lord, can it be on coming Friday, my lord?
No, it can't be. Yeah.
Or Monday, my lord? Kindly, my lord, my lord, because
Not before 29. 26. 26/9. Yeah. There's an application seeking an early date of hearing of so and so. Most of the matter is already slated to be listed on 26/9/2025. There would be no purpose in shifting the date of listing of this case for final hearing. Let the main case be listed on 26/9/2025. The application for early posting of the case is rejected.
obliged.
Item 25.
Notice 478 day.
Note.
Notice returnable on so and so day.
Hmm. 3110.
Yes.
Item 36.
Lordship. Lordship, as per the Lawazima order, I'll have to take fresh steps. in
Fresh
correspondence.
steps to be taken.
In item number 37 as well, Lordship.
37 order.
Okay.
311. 311. Item 38 for admission.
Admission Lordship. Lordship, as per the instruction, already 90% of the work has been completed. So I have an instruction to withdraw the CP Lord. So
You're not pressing it, no?
I'm not pressing it. I have instruction to withdraw the CP.
Work is, work is in fact complete, almost more than 90% of the work
That's right,
completed.
but you changed the yardstick. But for the fact that 90% of the work has been completed, we could have interfered. If you remember, that was the day when he mentioned and we listed. Anyway, since the Learned Counsel for the appellant seeks permission to withdraw this appeal, as it has almost become infractious, dismiss this withdrawn.
Item 39.
May please your Lordship. My Lord, this matter relates to appointment, selection and appointment of a principal of a college.
Yes.
Now, my Lord, the appellant before Rashid, he was appointed, my Lord. And his selection was challenged by the, my Lord, by the petitioner. And subsequently, my Lord, the appellant also filed a writ petition questioning the eligibility of the, my Lord, writ petitioner in the first case. Both the cases were decided together. And my Lord,
Chaudhary.
I-
How many research journals in UGC care listed journals? How many articles have you published?
My Lord, I have fulfilled the requirement. There was my Lord, re-verification committee that has given its report that my Lord, the writ petitioner did not, my Lord, qualify. And my Lord, out of 10, only one. Out of 10, my Lord, the writ petitioner in the first case, my Lord, had only one, whereas, my Lord, I fulfill all the conditions. Out of 20 papers which I submitted, my Lord, 18 were my Lord, either UGC approved or my Lord, peer reviewed, published in peer reviewed judgment, journals.
Where is the requirement? We will hear both of you. Let him remain the principal of the college. He has scored more marks than you.
No, my lord.
No.
Unfortunately, he's holding the
I
post.
am holding the post now.
You are holding.
Yes.
Then your appeal we will hear.
No, my lord. There is my writ petition has been allowed. His writ petition has been dismissed. That's why he is on appeal.
No. Acha. There are not two appeals, no?
No.
Okay.
One judgment, my Lord, common judgment.
My lord, his writ petition was a counterblast because I was not appointed because I'm not I did not get preference. I do not belong to BT.
I'll ask you to respond.
Yes. But no, my lord.
No stay.
Oh, yes.
No stay.
That will clarify that.
I was appointed in.
Clarification. If you don't write stay, how is it going to affect you?
My Lord, I was appointed in April
That's
2023.
all right. Take her.
No, Your Lordship, then, my Lord, let me submit, my Lord, why my case has been rejected, my Lord. Because my case has been rejected only one ground, that my case is an afterthought. My Lord, I did not have any, my Lord, occasion to challenge.
When was the appointment made?
My appointment was made on the 6th of, my Lord.
No, that was first time he was appointed.
I was appointed. No, my Lord, he was never appointed. I was appointed on 10th of May 2023.
Just a minute. Preference was given to
That he belongs to BTAD.
Only the qualification was challenged. I thought his appointment was challenged. No. What is this? They have not filed any case, I'm surprised.
No, my lord.
That is one of the grounds. See, notwithstanding the fact that he scored more than you, you were appointed because his journals, you pointed out that they were not.
No, not on that ground, not on that ground.
Not on that.
On the ground that he is a local resident of that area.
The BTC had to
Yeah,
be
it
given a special.
But then, my
And
lord,
there is already a judgment of a learned single judge that is
If
not
that,
permissible.
if that were the ground, why did you question his credentials?
Exactly.
no, my lord, after my appointment has been
And even
challenged.
otherwise, so what would you get that? Have they taken any decision to remove you and appoint him?
No.
No, there, Milord,
No.
the BTC is in hand is in glove with him, Milord. That's the whole problem.
Why did you come here?
Yes.
Then we will issue directions that you be removed.
Yes.
No, my lord, my
Chaudhary, tell me one thing.
my lord.
All said and done, you have been appointed, rightly or wrongly,
Yes.
right, as the principal. But you're kind of guarding against something which may happen later. He may come and question your appointment.
No, he has already questioned, my lord. His petition has been allowed. He has already come.
His petition has been allowed.
Allowed, and my
So
petition,
you are the responsible.
and my petition
Milord,
has been rejected.
Milord, let me point out, Milord. I first filed a writ petition challenging his appointment on the ground.
What has been passed in your petition?
In my writ petition has been allowed because, Milord, I.
Allowed is something else.
Yes.
Has the college been directed to appoint you?
Yes, yes.
You say that.
Yes.
So that order you are challenging.
Yes, no.
No, this appeal is submitted for hearing. List this matter. Or we say something.
Something better, Milord. They should comply with the court's order, Milord, authority.
Comply. Authority,
BTC.
authority is not before us.
BTC is before your lordship.
No, let it be admitted for hearing.
My lord, my
Why
play
get into that?
Yes.
I have
that
an
will-
IA, my lord. I praying for a status quo at least, my lord.
We reject that.
Then that order can be passed.
Your worship will see how my petition has been rejected. My lord, may I draw your worship attention
No.
to one paragraph, my
That
lord.
is something which.
My lord, the ineligible candidate will be appointed now, my lord. She doesn't have the eligibility.
File your response to this only.
Otherwise, ineligible, that report is there, my lord, already.
My
Re-verification
lord,
has been
my
done.
lord, it's a writ appeal. There is no requirement of.
That we know.
I'll show from his writ petition what was his grievance, Milord. From his writ petition.
My lord,
Nothing is required.
there is a
But then we are asking-
re-verification report, my lord. That report still stands, my lord, conducted by the director. On the basis of that, my lord, she does not have the eligibility to be appointed.
Public order publicly made has to be construed in the context in which it is made. Only ground is preference. And you never replied. In my lord, in his affidavit to my writ petition, he never raised all these points.
My lord,
That is what the single judge has
But
taken.
he has filed an IA. You respond to the IA.
Oh, yes, yes.
You respond to the IA.
Yes,
and
yes.
the main appeal will.
Yes, yes.
Yeah. An advertisement was issued on 1/1/2023 by the governing body of Goreshwar College, Goreshwar, inviting application for the post of principal of the college. The requirement under the advertisement was
54.
that a candidate must have minimum of 10 research publications published in peer-reviewed or UGC care listed journals and a minimum of 110 research score. The preference in selection had to be given to a candidate belonging to BTR area. In the selection process, the appellant scored 400 marks, 400.58 marks, whereas the respondent scored 427.4 marks. However, the appellant was appointed as the principal of the college, who was made to steal the march over respondent number 1 on the sole ground that he was a permanent resident of BTC area. his appointment was challenged by respondent number 1 by WPC number 3543 of 2023. While responding to the aforementioned challenge, WPC number 3543. The appellant also preferred a writ petition, bracket WPC number 598 of 2024. No.
598 of 24, I think yes. Mine is 3543, rightly recorded by Honorable Chief Justice.
Responding to the aforementioned writ petition, the appellant laid his hands upon the report of an RTI, the report under the RTI mechanism, that only 1 out of the 10 papers of respondent number 1 was published in UGC care listed journal. He filed a representation. The appellant therefore filed a representation before respondent number 5, that is respondent number 5 / Borderland University, for the needful. He also filed a writ petition. The appellant also filed a writ petition bearing number WPC 598 of 2024 for ultimately setting aside the selection of respondent number 1 by the governing body of the college. The appellant also presses for stay of the judgment in the meanwhile during the pendency of the appeal. Let Mr. Chaudhary, let Mr. K. Chaudhary, Learned Counsel for the respondent number 1, respond to the aforementioned interlock. Re-notify October.
2810.
Diploma.
Item 40 along with item 13.
Lord, instead of 2810, let it be 2910.
29. Yes, we'll hear you on some other day. Both the matters we'll hear on some other day. Before the vacation. Because the whole thing has been said. No, this is High Court grade 3, grade 2. Correct?
Grade 3, grade 2 for promotion to grade 1, my lord.
And Shetty Commission.
This has been stopped.
All the process has been stopped.
It was,
I'm in fact praying for an interim.
my lord, I
prayer,
don't
my lord.
understand why High Court is aggrieved. My lord, High Court, there is a grade 2, 17 posts are there, grade 2 from 17.
Anyway,
But I am the appellant, my
there are
lord. May I
many-
just
there are
address
many
your
stakeholders here. Those who would not have got into with the relaxation.
issue is very
We'll hear you tomorrow.
My lord, not tomorrow, my lord, day after tomorrow, my lord. Day after.
Wednesday.
Wednesday.
Re-notify both the matters on so and so date. This has to be done urgently.
Item 41.
Much obliged.
No, I didn't follow. Yeah. When have you already? Matter is fixed today in CAT.
It was fixed, you didn't get it.
So the division bench, the states have been decided by division bench.
Your Lordship, the division bench is not yet set in CAT since the date of the.
The results are already declared.
He couldn't have passed an order. Single judge could not have passed.
Results.
Your Lordship, if I may
Result
say-
has been declared. Give it to him.
Challenge.
Challenge this now, instead of passing a stay or getting a stay.
Lordship, I also got these results. To be fair to the court, I got these results. But your Lordship, if I may just submit.
What will I do with the stay when the entire process is over? Why do you have to be so steadfast in your approach? The result has been declared.
We'll challenge this order, Your Lordship, then. We'll challenge the results.
During the pendency of the OA filed by the applicant before the tribunal, the respondent / Northeast Frontier Railway proceeded to notify the schedule for the viva voce examination. The applicant is aggrieved by the fact that no stay was granted. The stay was not refused, but the application for stay was posted before a division bench of the CAT for the needful. So it appears that the result of the selection process has been declared by Northeast Frontier Railways on 5/9/2025. Its application therefore become in practice.
Your Lordships, the results have been declared. If appointments till the timing of division bench.
Sorry. It has become in practice dismissed. Now, your appeal also would be dismissed, no? You have to challenge this result. You have to say, how can we hear you? That also, if you're bright enough, you would allow that appeal also to be dismissed. Are you interested? We will do it.
No, Your Lord.
Or?
Obliged.